For those who do not know me, my name is Benedict. I've been doing personal injury cases since 1987. Approximate over 25,000 cases. Money-wise, we know it's in the tens of millions of dollars that I've collected from insurance companies. So we've got some experience in the room. We can talk about this, and hopefully some of the things I talk about you're going to be able to utilize today and today in your own clinic, and just overall as far as general experience in personal injury. Am I speaking loud enough for everyone? Okay. As we get in today, if you've seen the outline on this, we're going to go over your basic understanding of insurance, automobile insurance, liability insurance in general. Whether it's on a car or whether it's on premises, it's kind of the same principles involved, so the terms are interchangeable. And if anybody has a question along the way, what we might do is we might wait till we get to a different topic and then ask the questions before we get into the new topic, and just a show of hands. And if I miss you, I don't have my glasses on, if I miss you, then just speak up, say, hey, Lloyd. And I'm half blind, so for y'all who do not know, I'm legally blind. I actually have a retina issue that prevents me from seeing faces at 20 feet. So I'm face blind. And so you might, I actually see the faces, but does anyone know who Salvador Dali is, the painter? He has an interesting work of art called melted watches, melted clocks. That's what your faces look like to me at 20 feet. It's distorted on that. As I get closer, of course, I can see everybody just fine within 10 feet, but distance-wise. So anyhow, hi folks. There's a sign-in sheet. Please sign in. Verify your name. Make sure it's spelled correctly. And your clinic name. But for doing this since 1987, I've had a wonderful opportunity of learning every trick in the book. And the insurance companies have lots of tricks. So you're going to learn those pitfalls today. You're going to learn those tricks. You're going to learn everything you need to know in handling personal injury cases. Now, I will not be talking about workers' comp. That's for a different subject altogether. I do not handle workers' comp. I used to. But the last time I was in workers' comp, I found myself down at the workers' comp court arguing for a prescription reimbursement. The prescription was $7.20 that the insurance company was disputing. I had to go to a hearing to fight on that. It was an hour and a half, plus the driving, plus the $8 parking across the street from workers' comp. And I said, I'm done. So, but things are coming back, I understand, towards where chiropractic physicians are now becoming a little bit more involved in workers' comp. I think finally the insurance industry has realized that chiropractic care is more effective than just giving medications, as the MDs would do. Nothing against any MDs in this room. I'm just saying that that seems to be the general consensus of the reason why the insurance companies are gravitating back to the chiropractic field for a physio medicine. Anyway, so all right, let's proceed on. And you know, really, as we talked about, it's good that you understand really the relationships that the parties have. What's the relationship really of the attorneys, the insurance adjusters, the coverages involved, and really your clinic as a whole in relationship. And that kind of goes without really saying as to where you guys fall into the big picture of this. Obviously, patients who have been injured in some type of crash or negligent incident are going to need to have some care. That's the basis for damages, and we'll get into that. The first rule, this is like the first rule of Fight Club, the first rule of personal injury on this is I think everybody needs to know that a good experienced lawyer should be able to settle 75% of his caseload. If they can't, then either they're inexperienced, maybe they're not into the personal injury areas, they might be doing a little bit of this, a little bit of that. But 75%, and normally they can get 75% done from the time the patient, my client, is finally released. They've had all the treatment they need, they've reached maximum medical improvement, and we get the bills and records. Now that's a caveat on that, because a person can be released, but the clinic might not be the world's fastest on getting records out. So there are some clinics that just, you know, that paperwork's important, but of course they've got so much time to dedicate to the patients and the paperwork, and it could be a long time. I've waited sometimes for many months, many months, a year, to get records and bills after treatment. So I can't really try to settle the case until I get that documentation, and we'll talk about some things today that'll be helpful for you to put into those records. But to do this, you have to have some good skills. You have to have a tool belt. And in your tool belt, that lawyer's got to be able to develop a legal strategy. And when I say by legal strategy, if you guys, if you scan this, you don't have to do it now, but at your own convenience, that'll take you to a video on how I do the whole big picture of how I handle personal injury cases. And as I say in the video, you have to develop a legal strategy. And the legal strategy is the foundation for the case itself that ultimately is going to produce some type of value, and it becomes a commodity that the insurance companies want to buy. Now, why does an insurance company want to buy or settle a case? Sometimes they do, sometimes they don't. As I mentioned, 75% of the time I can usually get it to that point. But to do that, I tell everyone, imagine a blob of clay on a potter's wheel, and the artist is shaping that medium to some type of object. That object is going to have value. After the artist is done with it, he's going to, depending on his skill and the desire to buy his works, there's going to be a value to that. And the more that person has done a better craftsmanship, artistic value to it, the higher the value to it. You know, a 3-year-old making a vase for his mom on Mother's Day in school has a certain value compared to Michelangelo's David, for example. Why? Because you can see there's a value to someone who is the master of it. So it only makes sense that somebody knows what they're doing and I'm an artist. I'm an artist, not necessarily a lawyer. The lawyer is the right side of me, but the left side of me is what really dictates that whole building of the cases on that stuff. And every facet, your treatment, your documentation, your treatment, what the patients tell you, to make everything objective. And so I use that to develop a legal strategy. I make the anticipation of what the insurance company's defenses are going to be. And there's lots of insurance defenses out there. We'll get to a few of them in a little bit. But to really, you got to understand the facts on these things. It's not just facts, but you really have to understand, when I say verifiable, it's the objective facts. And think about this for just a second. When a patient comes in, let's say whether a previous patient of yours who comes back after some type of car crash, or whether a new patient or whatever the case may be, they come in and they're going to give you a history of what happened. They're going to say, well, I was driving down South Memorial. I was in Bixby. I was around 111th Street. It was 3 o'clock in the morning. Out of nowhere, a flying saucer flew out of the sky and crashed in the back of my vehicle. And you as the clinic are, all right, patient driving south on Memorial, flying saucer crashed into the back. Well, that's subjective. You just took some information from the patient and you put it in writing. Can that be verified? It means really, it has some basis of value to it, but insurance companies don't look at it as very realistic value. If I go to Arvez Bank, wherever that bank is around that corner over there, and I happen to capture a video, and by golly, a flying saucer crashed into a video, and I accompany in my demand package of working that case, building that vase, I've got some verifiable facts on that. Not only do they say that, but I've got a picture of it, and I've given a picture to the physician so he understands the biomechanics of how this collision occurred. Now we have a case. We have verifiable facts on that. So part of the job of a lawyer is to do that, very much so. And with skipping that and just presumption, a lot of people have a presumption. The conventional wisdom is, I can just say what happened. I was driving down there, or I can just tell them I missed 2 weeks worth of work. They should just trust me. They don't. They don't trust a thing you say on that. I wouldn't either. If someone's coming to me and wants me to pay them lots of money to compensate them for damages, I'd want to verify everything too, including the facts, the nature and extent of the injuries, but the damages. So those defenses that we talk about are things, the common ones are like pre-existing conditions. A person had 2 years before a collision at your clinic for neck and back issues I had, where they woke up with a crick in their neck or where they had a previous fall or another collision. Insurance companies are looking for that. So it's a pre-existing condition if it's relevant to the injury they have now. It's a re-injury if they've gotten over that and cured from that previous problem. Life has returned back to normal. They had full range of motion. There was no prognosis, no guarded prognosis. It was just they're released, they're done. That's a re-injury. That's not really a pre-existing condition. So there's a distinction there. Think about that. You got to be able to sugarcoat those damages. So in your records, if you're putting stuff, why would you want to do that? Well, the more you can assist me shaping that vase on that, the quicker that case is going to go, and the more likely that case is going to fall in the 75 percentile, be able to be settled without even a lawsuit. By the way, I should mention, just because it can't be settled doesn't mean it can't be eventually settled. I'm saying settled without a lawsuit. The other percentage of it, well, the other 25%, if I did my math right, is you're going to have a need for either a lawsuit or the case is just not feasible to pursue. After looking at the evidence, we found some facts that just no way we're going to file a lawsuit. Lawsuits cost a lot of money. They cost me out of my pocket in expenses between $5,000 to $10,000 in expenses. Here's just for a good example. Orthopedic trauma center. What do you think one of your physicians charged for a deposition there?
About $300.
$300? I like you. I have just. Does anyone know Dr. James Rogers? He's, bless his heart. He's not going to last long. He may be going to heaven any day now, but. We just did a deposition from him about a month ago, and it cost $3,000 for that deposition, plus $1,000 for the videographer, plus $500 for the court reporter. That's one deposition right there. So, and then you guys, everyone's got their own different prices on that. But they cost money. But to understand those, that's why we're letting you guys to understand really as to if you can get stuff in the record that really is objective and backs up the whole case, it really makes it for smooth. Not subject for this one here, but I've talked about the Croft studies. If anyone knows the Croft studies, Oklahoma, the Chiropractic Board of Oklahoma have really adopted, 20 years ago, they adopted the Croft cervical acceleration deceleration guidelines for treatment. And there's ways to rate them. They'll grade them from 1 to 5. If you guys don't know this, you can go on to the state board's site and you'll find the Croft studies on there, and it'll tell you exactly the parameters, grade 1 through 5, 5 being a surgery, grade 1 being a minor injury. Grade 3 is where a person displays neurologic symptomology, which could be headaches or radicular issues going down their arms or legs, and then ligamentous instability, which can be demonstrated through plain view x-rays. You don't have to have motion studies to determine that there's a slipping of the vertebrae or whatever the case may be to see that there's some type of ligamentous instability. That's a grade 3. A grade 3 recommended by the Croft studies will allow up to 56 weeks of treatment with 76 overall visits. Insurance companies freak out on that, but that's the way it is. It's, you know.
Yeah, but your records have to say Croft and the scale you're using, what they are. Otherwise, the insurance carriers decide that the patient's a grade 1, minimum coverage. So your notes have to say MIC Croft score number.
Yeah, I think it needs to make reference to it in some form or fashion. And if a person wants to go into their experience in Croft as a side note, that's great. I've been to, I've studied Croft, I've been to seminars, and I've got all the materials, and whatever. You can do whatever to lay out a foundation for that making a later argument. But again, that's part of that sugarcoating defenses, because they'll say, what's one of the defenses we see? Well, there's a gap in treatment. They took too long to get to you, where the patient had COVID and they missed treatment for 4 months and they finally came back. Or, pre-existing conditions we talked about. Another defense that comes into play is duration. The duration of the treatment was too long, too excessive. The treatment was not reasonable and necessary, and the charges were not usual and customary. That is every case I deal with. The insurance company is always going to pick apart your treatment. That's the first argument they do. Aside from the facts, as we talked about, they'll try to put blame on your patients. Like, well, they're 10% at fault because they sneezed just before the crash. These are all things that we sugarcoat these defenses and we address the elephant in the room early on, and we have it in the records. That's so helpful to the case. So that's something to keep in mind. A good lawyer is going to know this stuff. When you get this documentation before it's sent off to the insurance company, it's going to be another call like, hey, doc, do you think maybe we can say this differently? I'm not going to tell you how to write it, but can you amend this to say that, for whatever the situation is, to expand on it a little bit further if need to. The damages are the simple stuff. I mean, not simple to understand them, but the simple to know what they are. But medical medical bills is, one, current, past, future. Um, Get into lost wages, out-of-pocket expenses. Those are all kind of verifiable as far as papers and that sort of thing. You can find those things readily easy. That doesn't mean the insurance company takes them for face value, and everyone needs to know that. If you have a bill for $10,000, the insurance company goes, oh well, okay, $10,000. The first line of attack is going to be treating for usual, reasonable and necessary treatment, and usual and customary charges on that. If you ever go in here, you'll see referred to as the $5,000 Band-Aid. It's in the video. The $5,000 Band-Aid, as it goes, like a person has a scratch on their hand and they go to their doctor and the doctor says, oh, okay, scratch in your hand, and puts a Band-Aid on it and has them come back 3 or 4 times to check it out and sends a bill for $5,000. And I present that to the insurance company. Well, you can anticipate. The insurance company's going to say, wait a minute now, $5,000 put a Band-Aid on a scratch? And so no, I'm going to offer $150 for the office visit. That's what we don't care if they've got $5,000 worth of debt. That's their problem. We're only going to pay what's reasonable and necessary treatment, usual and customary charges. My job as a lawyer to get back in here with the experience is say, well, wait a minute now. That's not just a scratch. That scratch developed an infection. That infection turned into open wound care. That open wound care turned into disfigurement and nerve damage. It's a $5,000 Band-Aid, and you're going to pay for it. So it's my job to build up. Now, if I can't make it, I can't make it. But if I can get there and think outside the box and get creative, I'll do something. I've had scratches before on people's hands where I've taken a picture and they didn't have that scratch before, and this girl now is like, you know what? When I tan, it shows up. And by golly, it's a permanent disfigurement for the rest of her life. And so let's maybe get a plastic surgeon, do an evaluation on it, and another $2,000-3,000 for scar revision estimates, and let's build it in and support our damages. Build that vase with it. So that's a good lawyer is going to understand and know those damages and really how to expand on them. Negotiations is not just here's what I've got. What do you think it's worth? Here what I got back. It's actually it's depends on the lawyer and their techniques and styles. It's a series of things: offers, counter offers, and I just don't sit on the phone and say, okay, yeah, you have this much. Well, I want this much. It's presented with power. It's presented with persuasion. It's presented with documentation to be able to support the additional monies that we're requesting. Do we have to negotiate? Do we have to compromise? Generally, get a settlement, yeah. Rarely do I just get what I want, unless the injuries are so severe that it's a minimum policy limit of $25,000, and we have, a mangled arm, and they don't have enough money to pay for it. Well, that's usually, all right, Lloyd, here's all we got. Well, it's my job as a lawyer to look for more parties, responsible parties. Look for additional. Sometimes the car was borrowed to their friend, and so the friend's driving is at fault, but now the owner is at fault. But the owner, maybe he didn't know this person was intoxicated over at the bar, and there's a bar involved. Okay, now I get to go over to the bar for what they call dram shop liability for over-serving this person, and I just keep looking and building and going for it. Or maybe this kid was on the job. I find out, oh, he was on the job. We had a case here just recently. A guy hit my client, mangled her, head-on collision. He only had $25,000 worth of coverage. He was here from Arkansas and starting a job. Got into the facts. Insurance company's like, oh yeah, your client's got $600,000 worth of medical. Well, here's $25,000. Well, hold on. Obviously, can't take that right now. Got to look into it further. Then we find out that the person was hired in Arkansas to come work for this large corporation here as security. And they bring all their people in from out of state, pay for their hotel on this temporary job. So he's TDY, basically, temporary duty, TDY. Not just a military term, applies to the commercial industry as well. And so he's basically in the scope of employment. We have a $5 million policy now to go after. People would have just, an unexperienced lawyer wouldn't know to go talk to some witnesses and talk to the defendant and start learning some things about it. And you don't know this stuff because it won't be on the collision report. There's more to the story, and usually there is. So that's part of that understanding the damages, building damages, and doing proper investigation, verifiable facts. Reputation. I don't want to talk bad about any lawyers out there, but there are, without giving names, there are lawyers who will never go to court, have never been in court on that. Easy way to verify that. You just go to oscn.net and you can put in that lawyer's name and you can hit that and you can see. You can see all the lawsuits throughout the state of Oklahoma that they've handled, and you can actually go into each one and see how it ends, and there will be some. I'll tell you, most plaintiff tort, you're going to see a very, very small percentage of jury verdicts because we don't have to. A good settlement, a good case is going to settle along the way. We don't want to risk any money. Sometimes it's necessary to have a jury trial. But less than 0.1% of all lawsuits filed result in a jury trial. Less than 0.1%. It's such a small fraction that the whole system is trying to get it settled along the way. And there might be a winning number. Sometimes it doesn't happen. Rules, the worse the liability is, the more chance it's going to, like, who had the green light? And neither person there's no evidence. Who had the green light? One person didn't, one person didn't. One person's lying or one person just has a different perception of what happened. That's going to have to go to trial because there's just no way that they're going to settle and say, no, we're flip the coin. Big cases, real big cases do not, because you've got cases that are worth 20, 30, 40 million dollars. They're going to want to put it in front of a jury. I've got a case right now where my lady was shot 11 times by law enforcement. She was taken hostage in a bank robbery in Eufaula in 2016. And due to miscommunications and keystone copying going on, they confused her for a bank robber with her arms up, unarmed, broad daylight, 55-year-old registered nurse wearing designer clothes and boots, not even near the bank robber who had a pistol in hand. And the first 2 shots she received was in her arm because her hands were over her head. They were trying to kill her dead. She got shot 8 more times after that while she was on the ground. They kept shooting her. She's screaming, "Stop shooting me, I'm the hostage." The cops said that we didn't see her. The 10th Circuit said, your gun sure saw her. Saw her 10 times. Not one offer, not one apology, and the trooper that shot her got Trooper of the Year for saving her life. He's the one who, allegedly, that we're arguing. We go to trial in federal court September on that. So the bigger the case, the chances are, I've never seen anything like it. I've lost all respect, and I'm not saying I support her son. My client's son, her name's Julie Huff, it's no secret. Her son was a police sergeant in Oklahoma City who quit the force because he's disgusted with the corruption in the police department and the high patrol. He said, this is the most disgusting thing I've ever seen. Shot her on and just wanted to kill her. Put her in handcuffs while she's in the hospital. Bullet holes, leaking blood, put her in handcuffs because by grace of God. She's a miracle. When I touch her, I feel energized by God every time I touch her. There's a reason why she's alive. It's an amazing lady. And we're in a gag order. Can't go to the news on it. You won't hear anything about it at all. But when you see the verdict, it's going to be huge. Unfortunately, there's no money from the state. I think they've got $7 million at most that they can pay. But, anyways, I'll get off my soapbox here. All right, so that's really, you got to have a reputation. And so if there's anybody out there you work with, and we've got a lot of great lawyers in Tulsa, we've got a lot of people you got to be careful of too. So be smart about that. Let them know that there's different flavors for people out there. If you make a recommendation for somebody, your word recommending somebody is on the line at that stake right there. That you send them out to someone that scams them blind, then you're going to be guilt by association. So be careful on that. All right, let's move into it. First rule of personal injury. Actually, it's a second rule. If Satan owned an insurance, if he owned a business, it would be an insurance company. They lie, they cheat, they'll just rob you blind. Whether they're your own insurance company or whether somebody else's insurance company. You just need to be aware of that. And people believe, when someone says my adjuster, they're talking about somebody else's insurance. Oh, my adjuster called me. They're not your adjuster. They don't care about you. They may be nice to you, or they may not be nice to you. You are, the reason why they want to even talk to you is because you have a cause of action against their insured. They want to, that vase that I'm building, I'm going to sell to the insurance company in exchange for a release of all claims. That's what they want. There's a commodity there. It has value to it. The question is how much then it is. But Satan doesn't really care about that person, so don't think that they're so nice to him. They took care of me. Well, the reason why they took care of you on a car is because, man, that's black and white. I can pull up a book and tell you what your car's worth. I can't do that with the human body. I have to build that vase up for the insurance company. But that 2012 Honda Accord, I can tell you exactly what thing's worth, and and you had a rental car and all, or the repairs, I mean, that's easy. You can quantify those things a lot easier than you can bodily injuries. So normally the car damage is not that much. That's why they seem to be a little easier to work with on the car damage, but it's too late by it comes time for the settle the bodily injury claims. You got to have your strategy in place to get there. So we're going to talk about liability insurance, med-pay coverage, premises medical coverage, and uninsured motorists. And premises medical coverage basically is med-pay, and we don't have to go into that in just a minute, but I'll give you a little trick on that. For those who don't know, Oklahoma has minimum liability limits to drive. Everyone's required to carry at least 25, 50, 25. What does that mean? 25, 50, 25. 25 means they'll pay up to one person $25,000. What if there's multiple people injured making a claim against that same liability policy? Well, they'll pay up to 50 for everybody combined, but no one person can get more than 25. An example, you have 3 people injured. One person has $26,000 in medical bills. The other people have, let's say, $12,500 each. So the person that has $26,000 presumably is injured more, if you're going to use a medical bill as a gauge of severity of injury. So they would say, okay, you got $26,000, we can only pay 25. We can only cover up to 25. So your offer is 25, which is policy limit. The other 2 injured claimants, well, there's only 25,000 left because we only pay 50 out of the whole policy, 25 to that one person, and there's only 25 left. So we'll give you 12.5 and you 12.5. That's a simple example, regardless what their injuries are. That's a pro-rata disbursement on how they would do it. So there's a lot of dictation. You have to really understand what that means. You have to really, and we'll talk about that in just a second, how that plays into your strategy on treating patients, and it may make a difference for you, may not. So liability pays for basically the medical bills, current and future medical bills. That's part of the damages. Out-of-pocket expenses, a person had to get reimbursed for prescriptions, or they had mileage going back and forth to the physicians, whatnot. Pain and suffering, mental anguish. Does anybody know, can anybody describe, just whoever wants to jump in there, tell me what pain and suffering is?
The inconvenience of your life and having to deal with the whole process?
That could be part of it. That's a very small part of it, but that could be part of it. Pain and suffering is not necessarily ouch, I hurt, or to have anxiety about it or depression over those issues. Pain and suffering is what you can't do because ouch, I hurt. That's really how you prove pain and suffering. And that's something that really you guys really, if it's in your charts, your chart notes, it's building that vase. It's really helpful on that. The patients come in, they call it ADL, activities of daily living. And I've seen every clinic's got their own different means of doing that. Some is to actually have little happy faces. I know that Doc used to do that all the time, used to have happy faces. I don't think he does anymore, right?
We still do the charting, but we don't have the happy faces.
Yeah, okay. So used to have a sad face for I don't feel good to scale.
Not just happy all the time.
Yeah, to sad faces, and so that's just a pain scale basically, 1 to 10, 10 being the worst pain. Where are you as far as your visit today? So if they're what I tell my clients, if you're a 6, 7, 8, 9, or 10, or whatever your pain level is, and presumably the more the more you're injured, the higher the pain, or the fresher you're injured, the higher the pain levels, and over a period of time they're going to go down. But there should be an activity associated with that you inform your treating physician. And that would be like, well, Doc, I'm an 8, and the reason why I'm 8 is because I cannot lift my child, my 2-year-old daughter. I can't lift her. I can't mow the grass. I can't rake the leaves, and I can't go to work and do these activities. I work in a warehouse over at Mathis Brothers Furniture, and I cannot do these activities. I have to have my coworker help me, assist me, or I'm on light duty. And of course, the doctor will put them on light duty. They'll note the activities. Sometimes they can't do their job, but they'll do it anyways. They can't miss work. Doctor says, why don't you take a couple of weeks off that physical job that you do? I can't. I can't pay rent. I can't pay the bills. I got to work. My work hurt. That's working under duress, and I'd put that right in my records, working under duress. Patient was advised to be on light duty. Patient cannot for financial reasons, fear of losing their job or whatever. So it's working under duress, and that's got a lot of value in that statement right there. It lays out the foundation as to why that treatment plan may be longer, Well, the reason why he treated for an extra month and a half, 2 months, because he kept re-injuring himself due to his daily activities. He couldn't convalesce. He couldn't heal. He kept on hurting himself. It's not his fault that he was going to lose his house. So, and those are things that we get into on pain and suffering. Loss consortium, I put it in there because nobody knows what loss consortium is. Anybody know what loss consortium is?
Lack of playtime.
Away. Intimacy. Love and affection and intimacy. And so there are injuries that affect their intimacy, and that's something that is, you should ask your patients if the injury is severe enough. I mean, if you've got a lumbar injury on there, there's, or any injury, I guess, it doesn't matter. It could be an elbow injury. It could interfere. It has value to it, and it's something that we try to point out to the insurance companies. We don't want to go into details on it, I'll have people give me details. I don't need that, okay? I don't need that, okay? We don't. This is not the porn channel here. Let's stay out of that. But and then sometimes I'll get a letter from the spouse or the significant other or whatever, and just say, okay, are you having intimacy issues? We are, and the insurance company says, well, that's biased information. They're the spouse or the significant other. Well, I said, well, where else are you going to get that information from? You're going to get it from their neighbor? We hope not. They need to close their window if they do. But it just cracks me up. So, and then the minimums we talked about, that last number there, 25, and that last figure, that's for property damage. If that person, the defendant, at-fault vehicle crashes into 10 cars and totals out 10 cars, the most that policy is going to pay out is $25,000 for all that damage. They'll just have to take that $25,000 and split it up on that. All right. So, obviously a person can get bigger limits. You can buy up to whatever limits you want to. Insurance has always been budgetary. Insurance is, everyone in this room, I promise you, would rather have $1 million worth of coverage if they can afford it. And it costs money to get the bigger coverages, and that's the way it is. But we get what we can afford. And we don't need to over-insure for the risk we have. What's the rule in insurance? Basically, everyone says that, well, you basically insure the amount of what your house is worth. If your house is $200,000, you probably want to get $200,000 in liability. Now, somebody cannot take your house in Oklahoma if you're liable for, if you're a defendant who's found guilty, but they can get a judgment and put it on your house on there. So, so when you sell it, you'll have to deal with that judgment, or you'll have to file bankruptcy, which is what most people do. They'll file bankruptcies on these big judgments on that. So we talked about premises liability. That's just like in here. If there's a defect on the rug somewhere, and I'm walking and I trip and I hurt myself in the rug, and that's the liability insurance that the visitors would be making a claim for negligence on that. One of the biggest cases I ever had was a premises liability case, and it was against Mazio's. And premises liability also has what's called like a med-pay component. So you may not have a patient that's, if they fall at Homeland or Research or something like that, and the liability is weak. And it's like, well, it's clearly a pile of syrup on the floor you shouldn't have stepped in. It's open and obvious, which is a defense the insurance companies can get out of paying on. And they say, but you know what, we'll pay up to $5,000 in medical bills. Well, that's something that your clinic should probably know. And you should know that because that's an avenue for you to go ahead and file your lien against and eventually get paid for your medical bills on that. Some people might say, well, you got a weak case. Well, don't, just because it's a slip and fall, we know slip and falls are hard. 11% of all slip and falls can be settled. Only 11%. They're that difficult because Oklahoma is an open and obvious state. If the condition's open and obvious, then the property owner's not liable. You watch your step. That's basically the rule. You got to watch it in Oklahoma. It's like you're in Walmart. Don't step in the water. You should have, Well, I couldn't see it. Well, if you couldn't see it, they probably couldn't see it either. So you've got to prove that they knew about it or should have known about it. Walmart has a sweep schedule every 15 minutes. They go with clipboard. Stock boys walk the aisles. They go back there and say, "Yep, check 15, 16 through 28, clear," or clean up spill, whatever. They've got a sweep schedule on that, and the courts have determined that to be adequate because Walmart's in the business of selling product, not sweeping floors on that. So they're tough. And but the biggest case I ever had was, not the biggest case, but one of the biggest cases I had was against Mazio's in Grove, Oklahoma. It was icing outside. No way in the world would anybody have taken this case. But young lawyer Lloyd at that time said, you know what, I'm going to look into this thing because it was a severe injury. I mean, almost had to have an amputation out of a non-union, and it was just horrible. She was walking into Mazzio's, call ahead order, and walking down the sidewalk and hit an icy spot in the middle of February, hit an icy spot on the sidewalk, and her leg slipped out. And when it slipped, it stopped. When it hit the dry concrete, and when it did, her bone shot out her leg at that point. A horrible injury. Insurance company denied it. Yeah, it's act of God. It's ice. We don't cover that. No liabilities on Lloyd. You know, we don't even have Premise Medical to pay anything on that. All right. Well, okay. And so that was their version. And then the patient was going to physical therapy, Grand Lake Physical Therapy, and she had this bootleg on her left leg. And she sat down next to another lady, had a bootleg from a cast in there, and they were just rehabbing the upper part of her leg from the muscle sprains from that injury, hadn't got to the surgical part with the cast still on it. Same exact injury to the lady. You got the same injury. What happened? Well, I was walking down to Mazzio's. She goes, oh my gosh. The night before that happened to me on the same spot. Turned out that the little canopies off of Mazzio's in the daytime would have snow and ice on them, and they would melt onto the sidewalk. At nighttime, they would refreeze. They created the hazard because of that. A little investigation work, pictures, and then, of course, the adjuster, like, I told you I'm not going to pay a dime. Said, do you know Miss Pam Smith? No. Why should I? Interestingly, she made a claim against you, too. She knows you, and you denied her case. I have her testimony. I took her deposition. We're going to sue for punitive damages on this thing. I want full policy limit, or we'll see you in court. Well, Mr. Benedict, hold on. She knew she'd been had at that point right there. I should go back to the slide about, you know, if Satan owned a business, all right? They lie to you, all right? Okay, so that's what premises liability. Be aware of that. If you ever get that, it's worth asking a few questions. An experienced lawyer should or may know if those people at least have premises medical, and that's enough to make you feel better because they don't really dispute. You got $2,000, $3,000, $4,000, $5,000 bill, submit it to, and you get your bills paid. The patient won't get anything other than medical treatment, but it's a lot better than them not getting the treatment at all because the liability may be weak. Then again, they may have another Mazzio's case, who knows? Okay, so you got to understand there may be limited dollars out there, and there's certain situations you need to be aware of, like there may be multiple injured victims on that. Multiple injured victims, if you know the facts of the accident, there was 5 people hurt. All 5 of those people are competing for the same dollars that you guys are wanting to lien at that point. If you're aware of that, then that's one of the questions you kept back in my mind. If it's a surgical recommendation coming up on that, you definitely want to know those stuff before, unless there's some health insurance or Medicaid or Medicare issues that you guys can do. But yeah, the bigger the injuries are, the more that becomes an issue. And even smaller injuries. You might have, there's crashes sometimes I get involved in where there's 10 claimants coming in there, a couple of carloads of folks, and everyone was injured on that. That means at some point there may have to be some type of pro rata disbursement of minimum limits. There may be a limits issue. Be aware of that. And another thing too is if you're treating, XYZ clinic is treating your patient, but you also know the patient's been to 5 other medical providers. Those people there are also competing for the same dollars to get paid for. Something you need to be aware of. You know, the severity of the injury. Now, obviously, as we already kind of touched on, the more severe if a person's a surgical candidate at that point right there, then that you really need to be aware of that. And problems with the case, sometimes you just need to be aware that there's some competing problems with the case that may be like there's comparative negligence. Your patient may be, 40% at fault, because the video that the defense pulled up showed the patient backing up out of the parking spot and going through her purse. She's backing up and gets hit, and so they're gonna say, you know what, we'll pay for it, but we're only pay for 60% of her damages. Who knows the facts? But these are things that if you talk to a good lawyer that's helping the patient, they should keep you in the loop on that stuff. So if you're ever having a question, like, oh Lloyd, should I be concerned about this? Well, you probably should be. Yeah, could be limited dollars on that. So that's where I just kind of got ahead of myself. So you get a hold of a good experienced lawyer. Yes.
One of the doctors in my office treated, I don't know how much, $10,000 worth, and we got paid zero because we found out from the state of California he had back child support that took precedence, and any settlement he got from that case went all towards that. Is there any way to like ask ask certain questions to prevent that from happening?
I think so. I might be a little touchy on child support issues. So was that an accident that happened in Oklahoma or happened in California?
I'd have to review. It's been a little bit of time.
'Cause
it's
in Oklahoma, the doctors get paid before the DHS gets paid. On child support liens, doctors and lawyers get paid first. The person who doesn't get, it's out of the net amount where they get, the patient has to surrender it, and that's negotiable. I just had one where if Jade was here, I can tell you the exact figure. It was $28,000 child support lien from a deadbeat dad, and I got the insurance company the DHS talked down to take $2,000 and allow him to put a couple $1,000s in his pocket. So they have to realize, I'm not going to settle the case unless there's an incentive. My patient's not going to sign anything. He has to have an incentive. Right, wrong, or indifferent, it's a business decision. I would love the kid to get all the money that's owed for child support. That's not the issue. It's not a moral issue. It's just a matter of just trying to get the case resolved. And so I had to negotiate, and DHS said, yeah, we'll do that. So, but Oklahoma cases, doctors get paid before the patient gets paid on DHS liens or child support liens. California, if it's a California accident, who knows? I mean, good Lord. Whatever it sounds crazy, then that's a lie out there. Well, not only does he have to pay it, but he's got to pay it 1,000 times, and then he's got to, serve some jail time too. All right, uninsured motorist coverage is one that everyone really should know about personally and for the business too. Uninsured motorist is also called underinsured motorist in the state of Oklahoma. So it really covers when the defendant doesn't have enough insurance, that's underinsured, or when the defendant had no insurance, that's uninsured. And it could be one defendant. You can have two defendants in a case. It's one of those accidents where it's random, like I was hit once by the car behind me, and that car behind him hit and then cue-balled that car back into me. If only one of those cars is uninsured motorist, you can go to your own insurance. You don't have to deal with that one behind you. Sometimes we do that strategically because dealing with our own insurance company, we have a contract and we can enforce that contract, and they call it bad faith cases if your own insurance company does something wrong. But in Oklahoma, 40% of the time, you're going to be injured by a person with not enough insurance or no insurance. So everybody in this room should probably have uninsured motorists. Now it's budgetary. It costs $65 a year if you want to get it, but it's money well spent. Money well spent, because it doesn't cover damage to your car, but it covers your lost wages, bodily injuries, pain, suffering, mental anguish, loss of consortium, permanency, future damages, all that stuff we talked about that liability does, except the car damage. And you can buy it in different amounts. You can buy it for, you can get $1 million if you got enough budget-wise to pay that.
So if you succeeded at 25, you can go into uninsured motorists?
Mm-hmm. And actually, I won't get into it, there's actually a way to even bypass that. So let's say you've got $1 million uninsured motorist policy, and your case is not worth $1 million, but it's certainly worth it's compensated within that $1 million easily. You don't have to mess with that other person's 25. Your own insurance company will go get their 25 back. It's called subrogation. They'll get reimbursed back.
Does that hurt their premium?
No. And as you'll see later on, in the state of Oklahoma, and your patients need to be aware of this, when you start talking about med pay, and we're going to get into that a minute ago, and uninsured motorists, it will not affect your premiums. In Oklahoma, there's a law, and I quote the law up here, and we'll get to that in just a second. I'm going to get ahead of myself. Okay, med pay. So med pay is a good thing to know. Everyone in this room should know about med pay. Oh, by the way, last thing I should say about uninsured motorists is it's lienable. You need to lien this. Always lien the patient's insurance. If you get the patient's insurance, whether you know they have uninsured motorist or med pay or not, lien it anyways. Because, and I'll tell you why in here in just a minute, that they may not realize they have UM, because it can happen by default. But add them to your liens on here. Claim number or policy number. Claim number preferred, but policy number will work too. If you don't, you can get a policy number right off a collision report, The patient's got the little, oh, here's my State Farm on here. Does anyone know what a State Farm insurance verification card looks like, that red and white card? I love them too. You know why?
Because it's there. It tells you
It,
what they have.
it tells you the coverages. It won't tell you how much. It'll say the letter C for MedPay.
Yes.
Well, you got MedPay.
Yes.
That's probably at least 1,000. U for uninsured motorist. A for liability, which nobody really cares about that. On your own patients, we don't. Unless you got a patient that's their husband is, the wife's driving and she's at fault. Those are always fun. You got the husband-wife situations. I say that kiddingly. It's never fun. So yeah, you can ask the patient, can I see your card? And that way you know right up front. If not, you can learn that. A good lawyer is going to be able to tell you that. A good lawyer who has a relationship with you has got nothing to hide. Sure, there's MedPay. Go for it. I'll make the claims for MedPay. I don't take a fee on MedPay. No, but ethically, a lawyer should not take a fee on MedPay unless there's a dispute. So I guess some slick lawyer out there could probably make a dispute by saying, well, it's disputed because they delayed the claim for 2 weeks. So yeah, that's BS. It's there to pay your bills, pay your doctor bills, and a lawyer takes a fee on MedPay, then shame on them.
When is it subrogatable?
It's subrogatable.
I don't jump ahead. I'm sorry.
You jumped ahead,
I'm sorry.
and
Okay.
I'll get that
Okay.
fully explained. But come on. So the MedPay, you can buy different limits, as we talked about. It could be, if they have it. And again, it's a budgetary item. I would say that probably, a good 33% of my caseload has MedPay. So not everyone's going to have it, but when they have it, it's good to have. The person is allowed to buy different limits, and I've had people with $250,000 worth of MedPay. Crazy, but it's there. Very expensive on that. But they do have some defense language in there. Pays for usual and necessary charges, or usual and customary charges, reasonable and necessary treatment. If you look real close on the policies, and it varies from State Farm to Farmers to Travelers to Allstate, say different things. One, it can have exclusions, like it can exclude if your patient was on the job. So even if they make a workers' comp case or not, it excludes on-the-job situations. So if your patient is running a bank errand for their boss and they're on the job and MedPay finds out, they say, well, excluded, sorry. Or if they're in a car that is used for regularly furnished to them from their employer. So it's a company car, it excludes from that. So there's a couple exclusions on that. And they can say that, that you treated too long, or there's a gap in treatment, or we just don't buy it, or there are pre-existing conditions. They can edit those things, not edit, but they can audit those things, and they can make those arguments and dispute it. That's a legitimate dispute. Can a lawyer get involved in that and take a fee on it if it gets to that point? Yeah, but if it's a small amount, why, if it's $500 and the attorney fee would be more than going to the doctor's offices, why just sometimes get a free pass, maybe a complaint to the insurance commissioner saying they shouldn't do this, So again, make a business decision on that. It pays regardless of fault. You have a patient comes in and says, I caused an accident. Do you have MedPay? Great. Let's get your treatment covered under there, up to your limit on that. So it makes no difference. Now, named insureds, what they call first party or class 1 insureds, you can double dip. There's no subrogation. You can make a claim for it and collect that. Let's say they got $5,000. You can collect the $5,000 from, let's say, State Farm. And let's say the defendant has Farmers Insurance and they've got liability. Well, presumably there'll be a settlement with them considering your medical bills, and there's a settlement from the MedPay considering your medical bills. That's double dipping. That's where you're collecting from two different insurance sources. Now, you only get paid once for it, but it can make, let's say you only got 1,000 of MedPay up here, but yet the liability will pay the balance on it. Well, you just got 1,000 of it that didn't have to come out of the client's liability settlement, which is good. It puts more money in the patient's pocket, basically. So the double dipping, you'll hear that. It's not my favorite term, but it's coined. All right, so permissive drivers and guest passengers are class 2. You need to know this. There may be a situation to where I loan my pickup truck to Dulcie, and Dulcie, you are a class 2 permissive driver. I have $10,000 MedPay, and you're welcome to it, but if you were in a wreck with a bad guy and you settle with them, my insurance company wants to get paid back from the bad guy, so they can subrogate that. There is no double dipping. But there's a trick around that, and it's called excess med pay. So what's important is know your patient. If they say, no, I don't have any, you look at their State Farm card, for example, there's no med pay on there of the car that they're in specifically. But they weren't in their car. They were in somebody else's car. All right, well, you might have another car at home that has med pay on it. Now, it only works when you're in somebody else's car as a permissive driver or guest passenger. Can you go to your own insurance company and make a claim for med pay? Normally, you have to be in the car that has the crash. So if you're not in my truck, Dulcie, let's say you're in your car, then it's car specific. You might have 4 cars at home, and the one car you're driving does not have med pay, but they all do. You can't get med pay in those other cars. It's car specific. It will not follow you to their car. However, if you're in somebody else's car as permissive driver or guest passenger, it'll follow you to that. But there's some rules on that. You have to look at the car that you're in first. So, so you've got to look, and I think I'll go into it just a little bit. Basically, you have to look at the car that you're in first. That's the primary med pay. So my situation, example with Dulcie driving my truck, Lloyd's got $10,000. So she really can't make an excess claim on her med pay of the car that's sitting in her driveway, not involved in the accident, until her medical bills exceed mine, $10,000. So $10,001, she'd be able to make a claim for $1 to her own med pay. That's the excess of it. Now, what happens if I don't have med pay in my pickup truck? Well, then she can make a claim against hers. It becomes primary at that point. Her excess now pays it all on that. So people don't know that, and I can't tell you how important this is when you're trying to get revenues coming in for your clinic to understand how this Class 2 works. It requires you to ask a little bit more questions, or, in the alternative, requires to call that experienced lawyer that may be working on that patient's case to explain that to you.
I was under the impression that a passenger in a car, that theirs fell under liability, but I've been told no, it's considered med pay.
I guess it could be liability if the driver is at fault, but what if the driver's not at fault?
Okay.
And remember, it's med pay doesn't take fault in consideration.
Right.
So technically, you can make a med pay claim against, if you're a passenger in someone's car, you can make a liability claim against them as a passenger, and you can make a med pay claim against them.
If they were at fault.
If the driver was at fault.
Okay.
You'd be able to get both, technically. The only difference is that because it's subrogatable, the liability will set it off. They'll say, okay, we got $25,000 coverage that will pay you. We've already paid you $10,000 in med pay, so we're taking that off our offer. Your offer is now $15,000. Does that make sense? That's how it's actually, the term is, it's subrogatable if you're a Class 2. Class 2 is what? Guest passenger or permissive driver. So it's subrogatable. You don't get to double dip. It's subrogatable or set offable. That's not a word, I'll make it up. It's set offable. It just means that if you're going against the driver who's at fault, they can, you can get exposure to both coverages, liability and med pay, but there's going to be a set off. They say, it's 25, but we already paid you 10, we paid your medical bills, now you only get 15, and you can get away with that. That's when you look at uninsured motorists. Well, do I have any uninsured motorists at that point? When you hear policy limits or severity of injury, you always think of uninsured motorist. That's the first thing that hits my mind. Well, let's take a look at uninsured motorist. One thing I didn't mention of uninsured motorists, I want to go back, and I hate to digress, but you need to know that just because a person doesn't have that U on their insurance doesn't mean it's not there. In the state of Oklahoma, uninsured motorist has to be offered to you in writing in Oklahoma. So you go buy Farmers Insurance, old Charlie Dickerson over here, he's selling policies all day long, and he says, okay, Lloyd, do you want to have uninsured motorists? Well, no, I don't want uninsured motorists. Okay, well, here's this form required by law. You need, says, I reject this coverage. It would only cost me, $65 a year, and I need you to sign this. So that's a written offer with a rejection. Or it might say, no, I want to have $100,000 uninsured motorists, whatever that option is on that. The form is by law. It's a state form that's designed by our legislature, and it looks the same whether it's Farmers, State Farm, Allstate. It looks all the same. But it gives that selection. Sometimes the insurance companies lose those forms. Old Charlie may have lost it, forgot to forward it on, and can't find the paperwork for whatever reason. It happens frequently. When that happens, the law punishes the insurance company by saying that you at least have to offer. You can't prove they rejected it. You have to at least offer $25,000 worth of coverage. So when somebody says, no, there's no UM, that's uninsured or underinsured. Remember, it means the same thing in Oklahoma. I want to see it. I want to see that form before I make that decision. It's a stone that I think is legal malpractice unless I don't investigate. I think that's just foolish to not look and ask for that form. And the insurance company's like, well, we just had one here 2 months ago. Yeah, I guess we can't find it. Okay. Then that's cool. So that's $25,000 that we got, in addition to the monies that we got from the liability. All right. Any questions on that? I'm going to go in to break this down so you can kind of see this in a better highlight for you right here. But you just need to be aware of what a Class 1 and Class 2 is. Class 1 is they're a named insured or a resident household member. That's another thing too. You might have a college student that their parents live in Oklahoma City, but their kid is going up here to TU. And they've got an apartment at the dorms over here. And basically, they're covered under their parents' policy. They might be 23, been in college, about to graduate. They're covered under their policy at home. And that's something we need to take a look at. Because you can have multiple residences. You can be, your main primary residence is at home with folks. I go there, that's when I'm not at school, I'm at my folks' house in Oklahoma City. So, and there folks in Oklahoma City have got policy, and they've got uninsured motorist or MedPay. The same thing applies. Resident household members are covered as well. That's a named insured or Class 1 insured. Class 2, again, is just a stranger. It's a friend. It's somebody it's just you loaned your car to, or they're a guest passenger in your car.
So class 1 would be the student out of town going to college, correct?
Say again?
The class 1, the student be the class 1 classification?
Yes.
Okay, thank you.
Okay. I wanted to give you guys an example of how that works in dollar-wise. Under the Class 2, let's say there's $2,500 for the MedPay. Your patient is a guest passenger or named insured, or what we call Class 2. Or Class 1, $5,000. So let's say the Class 1 is the car that they're in. Remember how I told you that the primary MedPay is the car that you're in if you're not in your own car? So you're a Class 2, and let's say you've got the car in the driveway that wasn't involved in the accident. You got $2,500 there. So basically, you've got, well, $7,500 is total coverage. You got a $5,000 or $6,000 medical bill. So what happens? Well, what would happen there is the primary would say, okay, we've got the first 5, but as we know, we can't get that Class 1 because we've got to pay it back. It's a wash. So it's kind of like a deductible. Look at it as a deductible. So you go back and see what the exposure is. Well, there's $1,000 exposure. You got medical bills of $6,000. So what happens is Class 2, non-subrogatable. Oh, excuse me. Class 2, subrogatable, has the $2,500. The Class 1 at home has $5,000. So you got medical bills, $6,000. Treat the first $2,500 like a deductible, and you'll collect $3,500 from the Class 1.
Do they always come after it? Do they always subrogate it?
Always. It's in the policy.
Always.
Now, can they forget it?
Right, that's what I'm wondering. How do they?
They can, but they can come back and get you, and they can get you with cost too. And they can go after the doctors who took it too. So who's exposed? Well, the person who got the money is exposed, but who also is exposed? The doctors. So if the doctors got the money, they're exposed. That, well, yeah, we filed a lien and we got it. If you collect Class 2 MedPay, it's subrogatable, the patient doesn't pay it back, they're going to come after you. And it can happen, and it does happen. And ouch, and there's interest, and there's attorney fees and stuff. So my advice is don't collect MedPay that's not your patient's. If your patient's a guest passenger or permissive driver, use it like a deductible and investigate the Class 1 stuff. The car at home. Stay away from it. Unless it's carefully orchestrated, unless you've got an experienced lawyer that knows what they're doing on that, because that can be negotiated, the payback on that. It's touchy, but at least you know there's a strategy there that really works on that stuff. If anybody ever needs to use the restroom, they're down the hall right here. Just please feel free to come and go. You're not going to interrupt me at all on this. Okay, so these are things we kind of already talked about. We already talked about that if there's no primary and it's all excess, then your excess is primary. So if your car that you're in is a guest passenger or permissive driver. Now, what I've overdone is I've not talked about the obvious. The obvious is if it's your patient's own MedPay and they're in their own car, that's no concerns at all. No subrogation, double dipping, and that whole deal. So I want to reiterate that. And that's what usually happens most of the time. But in today's world, there's a lot of loan cars or there's a lot of guest passengers. Your household members are not guest passengers. Your household members are class 1. So mommy's driving, little Jimmy is in the back seat. He's a resident household member, all right? So that's class 1 too.
So even if I have State Farm and I'm hit by someone that has State Farm, that's not subrogatable?
It is subrogatable, but I've seen them waive that.
Okay.
And they'll say, we don't want to sue our own insureds.
Okay.
So, good point. Small exception, not a rule.
Okay.
It doesn't work for everybody. State Farm, I've seen that. I don't know if anybody knows this, but I have a class action lawsuit against State Farm on MedPay. They subrogated on class 1, not just to one of my clients, but to 2 of my clients. They sent letters out, actually got a check sent to them from the liability on that. You can't subrogate against named insured state of Oklahoma. And I filed in federal court, and this class could be, when it's all said and done, hopefully I ring their bell pretty big for that, because that's just it's state law. The law, Title 36, Section 6092 is the only statute that we have on MedPay, and it clearly says no subrogation for class 1s. That's what it says. If it's an out-of-state driver that comes in, we have an Arkansas resident has an accident in Oklahoma. No subrogation, because Arkansas allows for subrogation on class 1 insureds, for named insureds. They allow it. Oklahoma doesn't, so if someone's in Arkansas, comes over here and gets to an accident, or Kansas or Texas or New Mexico or out of state, there's no subrogation on those because it's our public policy. So public policy dictates how insurance companies are going to be treated, for Oklahoma laws are going to prevail on those situations on that.
Question. On MedPay reimbursement, I play it safe and file a lien on those MedPay if there's no third party and there's just MedPay, just to play it safe. Even if they have third party, I put MedPay on there. Is that a waste of time?
Never.
Okay, and I didn't think so. And then also, it seems like sometimes, depending on the adjuster, case by case it's different. Some adjusters don't care, they'll send it right directly to the attorney or the patient, and I want it to come to my provider. How can I handle that?
It's, and I can tell you there's kind of a section here, but I'll go over it right now real quick. There's some of that building that vase sometimes is all about strategy, all right? So there may be a couple reasons why that check may not end up in your hands immediately, all right? What if it's limited dollars on that? If it's limited dollars, then that's all the money that goes into the equation on that, and that might have to be subject to some type of negotiations at that point. So we've got $40,000 in medical bills, let's say, but there's only, $2,000 in MedPay and a $25,000 liability policy. So there may be other lien providers on that. So the competing lien holders going after the same dollars, that may be an issue. There may be a numerous amount of issues. Most of the time, you should be able to get the checks, though. Most of the time, I can't say it always. In my clinic, my office, most of the time you're going to get those checks, but there sometimes could be limited situations where we're going to have to probably sit down and possibly look at an interpleader or negotiation of medical due to whatever the circumstances are. Shouldn't be that many, but with some offices, though, there are some law offices, I know for a fact, will sit on that MedPay and not pay you that MedPay or look for ways to beat you out at MedPay or whatever. Not even tell you about the MedPay, whatever the case may be. I ask the checks get mailed to me so I can make copies, scanned in my electronic file, and then I can disperse it out so I know that it's done. So if so we're keeping track of balances and incoming and outgoing medical bills and that sort of thing. So there's a formality why it may come to me. Sometimes they'll say, just send it out to, I don't care, put it out to the doctor. My name may be on the check, even though I don't take a fee on it. I still want to have control on that situation sometimes, because the insurance company say, well, we're not going to pay all their, we've reviewed the medical bills, and this $5,000 worth of bills, we're only going to pay $1,000. We've read it through, and we've had the bills reviewed and utility reviews, and that's what we think is reasonable and necessary. And if the lawyer is aware of that, then we're part of that whole the whole problem solving of that particular issue right there. So that's another thing that comes up. And like I said, there could be a numerous amount of things, the reason why it may not come straight to you on that. But for most part, you should be able to get that. If a MedPay check goes to a lawyer and the lawyer sits on it, won't tell you about it, won't give you the accounting on it, there's a rule, and it's at the end of this literature here, dealing with difficult lawyers. It's Rule 1.15. And we'll talk about that because you actually have power to be able to get that check from that lawyer who's sitting on your monies on that. All right, so, all right. I don't know, a few of these slides here I've thrown in here just to kind of give you guys an idea, but this basically is a law that says really, I don't think the statute's quoted in there. I know it's, there it is on top, Title 36. This is a statute that says that insurance company cannot retaliate for a person making a MedPay claim, right there. You should be familiar with that statute. If the patient says, well, I don't want to make a claim against my own insurance company because they'll send the insurance mafia and kick my doors down with machine guns and cancel us. So the law says they can't. One, MedPay's no fault insurance. It has absolutely nothing with fault. So whether they caused the accident or didn't cause the accident, they cannot raise your patient's premiums, they cannot fail to renew their policy, and they cannot cancel them. It is against the law, and that would be a huge lawsuit if it could be proven the insurance company had terminated or canceled or raised your premiums because of you being involved in an accident and making a MedPay claim. We know this because when insurance company raises your premiums, by law they have to send you why. Most of the time it's two reasons. One, it's an annual insurance premium increase that the Oklahoma Insurance Commission approves for all insurance companies because, by golly, insurance companies, they got, devil got to make us profit. So there's these annual premium increases. It has nothing to do with them making claims. More frequently what happens is your patient loses an accident-free discount. What is that? Well, I didn't cause the accident. Well, that's not what an accident-free discount is. The accident-free discount is you don't have any accidents, whether it's your fault or not. The moment that person crashed into you, you lost your discount. Technically, the defendant owes for 3 years of what your premiums are now. That's additional damage. Oh, okay, and all medical bills, lost wages, pain, suffering, oh, and I lost my discount. That's going to be $700 over the next 3 years. What's part of the damages that you're going to get back from the at-fault party? They cause this problem on that. All right, so, but you need to at least reassure your patients that there's no retaliatory for that. By law, they can't. Well, they go, well, I don't want to tell my insurance company. Well, okay, now you're going to get canceled. First thing, page number 1, you have a duty to report all accidents to us. If you don't, they can cancel you. Now, if that's what you want, I guess, well, Lloyd, just don't talk to my insurance company. I have to. I mean, you'll be canceled. I don't want to be committing malpractice on your part by getting you canceled.
I have a quick question on MedPay. So I have several patients that call their actual people that sold them the policy, State Farm. They'll go to their agent and they'll say, I say, you have to open up a MedPay claim, and they will call and they'll say, oh, my agent said not to do that, it wasn't my fault, and they won't let them open the claim.
Well, we can ask, there was a patient of Dr. Kate's office over here.
$100,000 settlement because her agent told her not to.
Yep, I
open
have
a
3
MedPay
that do it. It's all State Farm.
So you want to get those recorded, and of course that's.
But the patient's like, oh no, they told me not to. They told me it was double dipping.
Happens all the time.
Yeah, I pre-warn my patients. I tell them, you have this, you have the right to use it,
I
no
tell them
penalty,
too, and my
and
agent
beware,
told me
they're
no,
gonna
it was
say
double
this.
dipping.
Right, then ask them why they paid the premium.
I
Why
asked
did
them
they
that.
pay
I'm
the
like,
premium
this
if
is
they-
like icing on the cake.
Yeah.
Go after it.
Yeah, I'm sure it was probably a $5,000 MedPay on that deal, but now that they just got a couple hundred thousand dollars.
But I threatened her with the bill. I'm like, you need to go after your med pay.
Good for you.
Yeah, no.
So what was the fine against State Farm for the judge doing that? The
Say
fine
again?
for the agent saying don't file your MedPay.
Oh.
Dr. Kate's office.
I'm not sure.
Dr.
I'm sorry?
The patient got how much from State Farm? The agent said.
It wasn't State Farm.
Okay.
Who did she say? Safeco? North Star. She had North Star. And she's been in maybe 10 accidents in
Right.
the last 5 years and used MedPay on every one of them. And wasn't at fault. And her last accident, she called the adjuster and she kept telling us the adjuster told me I can't use it. So we said, well, let's record it. So we sent her into the office and we recorded it. And she just got a $100,000 settlement.
Good, thank you.
Above and beyond everything
Did
else.
she buy you
Yeah.
roses or?
All right. So these are some of the things that you probably need to have up front on this. Is again, just the patient's version. The flying saucer crashed into him. Can they be verified? Biomechanics in the SOAP notes are always good. You understand the nature and how the accident occurred. If a person's saying that their head was turned to the left at the time of collision, that needs to be mentioned in there because that may have a lot to do with the mechanics of the injury itself on that. Just whatever the example is, the more we put in records. And records, if they could be legible, that would be helpful. Typed are always best. There are some that write as worse than I do, and no one can read my writing, and I didn't think it's possible. Collision reports are good because, again, you got the biomechanics built into from the investigation. Get a copy of it, you can. Keep it inside the chart for two reasons. One, so you understand the nature of the accident. Two, it also has insurance information on there, too, so you file liens. Different parties. You may not be aware from your patient, but there might be 2 or 3 different defendants that are all listed on the collision report, at-fault parties. Also, if I'm in a lawsuit and I depose the doctor's got the police report in his chart, well, that's historical, and it's not hearsay anymore because it's in his chart. And it's actually being used for historical purposes, not for the truth and veracity of the facts itself of the collision report, but for the historical purposes that the doctor relied upon to treat the patient. In other words, it's a backdoor way I can get around the hearsay rule and get that introduced as evidence. So it's always good. So it's good to get that. If you don't have one, hopefully the attorney, if your patient has one, is going to have a copy they'll share with you on that. Photos and videos, if you understand, if you got videos of the accident are great. I mean, if you just happen to be captured in a bank camera and the patient's got a copy of the video, show how they're crashed in the parking lot, that's awesome. Photos of the car damage, photos of their injury, their trauma is always good to have in the patient's chart. Again, it's something that helps you objectively have something in your chart that substantiates the injuries. Yes?
If it's like Operation Slick Streets or something, then do you recommend that we tell our patient go to Quick Trip and get an accident report and at least fill out your version of it?
It's required by law if you have $300 or more damage. So they call it Quick Trip Report. You can get it online from Oklahoma City or Tulsa Police Department. But you're required by law to do that. Okay. And so some people don't like, I'm not going to mess with it. I've had little situations I didn't mess with it, but oh well, I'm not promoting it, but that's what the law says. There are situations though where if there's a video, just so you know, that stuff gets looped over every week, every 2 weeks. If a patient, they should call a lawyer up front. That lawyer's going to say, if this happened on video, get it. Oh, they're crashing my rear. There's not a big question. Really? You don't think the insurance company's going to challenge that? Okay. They make stuff up. I go back to the devil slide again. Says, you're dealing with Satan, right? They're not going to say, oh, okay, it happened that way. Oh, all right, well, there's a check right here. Recorded statements, that's something, if you get a copy of the recorded statement from the patient, and it's in the chart, you at least understand what the patient's telling the insurance company on that. It's something that I always get, and I try to get one from all the witnesses as well. You don't need that in there, but you do need to know what your patient's describing because you may get on the history, well, I've got neck issues, my shoulder issues, my hip issues, and then you look at the recorded statement and it says, I was a little tender. Well, we're going to need to that tells you at that point there that you're going to need to focus objectively on these areas as to why the symptomology took a while to go ahead and manifest itself. We all know that you're in a crash, it could be a couple of days, it could be a couple of weeks before these symptoms start manifesting themselves. And sometimes you have these biomechanical deficiencies. I got a sore left knee. Well, in 6 months you're going to have a sore right knee, I bet you. Your weight's going to shift on that, and that's just the way it is. So these are things that you at least understand and have it mentioned in the chart legibly. Impact versus injuries. These are defenses you need to be aware of. You know, the insurance companies love to say, well, there's only $200 worth of damage to a car. How hurt can they be? Well, I can tell you, you can have severe injuries at low speeds, as we all know. But you need to be aware of that because that's going to be a defense that the insurance company is going to focus on. As a lawyer, what I'm looking at is looking at all things. Well, are we driving a Hummer and then we're hit by, we're not going to have any. You hit those things with a wrecking ball and there's no damage on it. But yet, as we know, taking the 2 jugs of milk and hem them together, that milk's going to splash on the inside. Our occupants in the vehicles are that milk biomechanically being affected by the trauma. It being exchanged between the forces of the vehicle, the vectors, and everything goes along with it. But you need to be aware of that, and you need to be able to support that. You need to be able to medically explain away the nature of the injuries based on this. Well, their head was to the side. Or, they do have a pre-existing condition that I treated for past that made them more susceptible to injuries. So there's a lot of ways that we focus on this and sugarcoat those defenses, but you need to be aware of them. Comparative negligence. Your patient was going 5 miles over the speed limit. Well, the insurance company's going to make a mountain out of a molehill on that one. So you just need to be aware that that means there's going to be an issue from fault standpoint. Nothing you can do with it, but just be aware of that. Delay in treatment. I was going to take over-the-counter medications for a couple of weeks, see if it went away. Everybody in the world doesn't want to go to the doctor and wants to give it a chance if it's just something that it's manageable. I'm managed with it, but it got worse and worse and worse, and they ended up going to get care. Insurance companies just make it sound like, well, you're never hurt. Well, you were talking to your friends, found out you're going to get some money out of the deal, so you decided to go ahead and treat? Is that what happened? Satan says a lot of stuff like that. Gaps in treatment. They missed her treatment. You had 26 treatments in the treatment plan, but for 4 weeks they had to go to their job took them on location to Utah, and they had to do something out there. Well, if you're aware of that, you know that ahead of time. Well, let me make a recommendation of I've got a buddy in Provo, or find you a doctor there that you can at least get treatment. Or in the alternative, I'm going to give you a home exercise program to get you through, Band-Aid wise, in the meantime. And call me, I'm here, whatever. Whatever that we can do to sugarcoat it and manage that. Be aware of that. Sometimes gaps happen, people disappear, whatever. COVID was a huge problem with everybody for a while. Duration of treatment, the insurance companies love to say between 18 to 25 visits. That seems to be kind of a go-to. I know there's people that require a lot more treatments than that, depending on their lifestyle, depending on their physical history, whether they needed more on that. Some people, the guy that works at Mathis Brothers in the warehouse, he's going to probably be out 40 visits because he keeps re-hurting himself because he can't take off work. He can't convalesce on that. That needs to be explained in that. Duration of the treatment, when you anticipate it's going to go longer. And you should probably get maybe a recommendation. I tell everyone you should probably, if a person's not responding to care and they've got some type of neurologic, symptomology, they probably need an MRI, probably need to be seen by another physician, get a second opinion on that at that point there. And they'll say, you know what, yeah, continue with the chiropractic care, but we're also going to maybe introduce the idea of maybe some ESIs or something else, or maybe some muscle hardening, some physical therapy or something, some alternative deal. So think about that, because basically the way the insurance companies look at it is unsupervised treatment when you have 40, 50, 60 visits. They're like, oh, the doctor just went crazy on this. He's going to treat till the cows come home. No, we sent them out for a second opinion. It's verified. An orthopedic specialist came in and said, yeah, that's really the best course of treatment for them at that point. It could be numerous reasons for that, but it's good to have, when you get up there, be aware if it's going to be on that. Know that the insurance company is going to look for some type of explanation. If you've got pain levels of 1, 2, or 3, and you're going to be going beyond that, I can tell you, insurance companies don't want to pay for that. They'll say, you know what, you can get a bottle of Tylenol and take care of those ones for you. We talked about Croft studies before, so I won't go over that. If anyone has any questions on that, they're always welcome to email me or call me, and I can go into a little bit better detail on how Croft is better explained. Dr. Williamstein, you just made yourself a good point a minute ago on that.
On Croft, about 20 years ago, they had little posters. I used to send the insurance companies stuff, and the insurance guy said, that's just useless, we don't want to see that. So I quit putting those cross posters, 9 posters. The patient saw them and signed off on them, so it was in my record. I used to send them, and some carriers don't like crop anyway to begin with. Was that a good thing or a bad thing to put the cropped posters and notes in files?
Yeah, yeah. I mean, it's a great idea. Anything that supports the treatment, obviously. Any medical journals, any treatises, any experience you've had in that area there, any side studies you want to put in there, that's all part of the record. So that's good. Just makes for a stronger way to explain the injuries, and that's always good. We talked about, if your duration is going to last longer than that, what are the competing factors? It used to be Mercy guidelines. Anybody remember the Mercy guidelines from the late 90s? Mercy guidelines, I didn't like them, but they did have some good points. It took consideration as your duration of treatment to have in there other competing factors. Well, the person has osteoarthritis. Has nothing to do with the accident, but it's going to take them, they have fibromyalgia. There's going to be issues why people take longer to treat. And so these should be in your records if it's there, you know about it. So it requires a little bit of inquiry. Of course, the defense is continued. We talk about pre-existing conditions, credibility issues. Credibility issues. A patient. I don't want to say too much because there's, as that Atterbury commercial says, good things happen to bad people, or bad things happen to good people, or we're all bad people, or something like that. But everyone's got a skeleton in the closet, and that may not have anything to do with it. But if you've got a person who's been arrested for fraud of some sort, they've got a criminal history that involves fraud or misrepresentation, it don't matter what you do. Their treatment's going to be questioned. You really have to have objective. You can have the biggest liar in the world, but if they've got a fractured leg from the accident and that x-ray shows a fracture there, it don't matter what their credibility is. Why? Because it's objective. So make your records objective if you've got credibility issues. How would you know that? Maybe because you just know the person. I don't expect you guys to do background checks on your patients. I do on all my clients. I do opposition research on the defendants too. So opposition research for everybody. Anybody watch Better Call Saul?
I love Better Call Saul.
So you know who Fallen Jimmy is? Slippin' Jimmy, Fallen Jimmy. The character has always got a slip and fall going on and keeping Saul's business in business. That's a person that's had numerous cases before. Credibility-wise, insurance companies run what's called an index. Once they get the information they need, they can go in there and see every claim he's ever made before. Health insurance claim, liability claim, workers' comp claims, everything. They know this. So if you've got a Slippin' Jimmy in your office somewhere, then you just need to be aware that that's going to be a little hard. This is antiquated right here. I would say really I'm seeing the average is probably between 4,500 to 6,500 is what I'm seeing now for treatment. And this original slide was made, that was about maybe 8 years ago. Cost of living's gone up since then. Okay, so we talked about ADL. I always try to get ADL in everything I do. One thing's really good on my standpoint, you should probably know, the more objective that ADL is, activities of daily living, what could they do before the crash? What could they not do after the crash? That is what really ADL is, which is the basis of pain and suffering, as we talked about. Fitness trackers are great. I've got my Apple Watch. I was walking 5,000 steps a day before the crash. How, can you access your data on your watch? Yeah, I can. I've got 6 months before, a year before, whatever. And you pull it out, and it shows a bar chart of all these activities you have. Average step, average step, average step. Date of crash, all of a sudden this activity drops down. Well, do you think that the patient's making that up? No, they're hurt. They can't do the activity they used to do. So that's wonderful. Insurance companies are fearsome. They just fear this type of evidence. The gym's another one. I was working out at the gym 3 times a week before the crash. Did it for 2 years. After the crash, I go get the gym records. It shows hardly anything. Then maybe 6 months later, they try to get back in and try to work themselves back into the same level of activity they were pre-crash. That's objectively demonstratable. I can do that on a spreadsheet. And boy, I tell the insurance companies, they just hate to see that stuff. Working under duress, we talked about that. Work in school. Are you guys giving work restrictions? If you're not, consider it. Just tell your patient, I'm going to make a recommendation that you do light duty. I'll make a recommendation you stay off work. Insurance companies will not pay for lost wages of your patients unless it's medically supported. So Have something in your record to support that, or the separate slip. Whether the patient acts upon that or not, well, I recommended they didn't. Now, the insurance companies are always like, well, I'm not gonna pay you. The doctor told him to stay off work. He couldn't, Dodo. He couldn't get his bills paid. He's gonna lose his house.
In my notes, I put down patient to slow down or work tolerance.
Okay, do what they can,
Okay, is that a decent phrase?
Yeah. You just use the word working under duress. That's a buzzword under Colossus. Everyone knows these claim assisting softwares the insurance companies have. Those working under duress, if they go through and somebody summarizes your charts visit by visit, if they see duress in there, working under duress, that's a buzzword that automatically adds more value to the case. So, yes.
I've had one attorney have a problem with me using the word like under duress. They're working and they're constantly aggravating the problem. So aggravation versus exacerbation, which do you prefer to see? And does, in your opinion, are they interchangeable, or does one have in court have a different,
I think they're interchangeable, but it depends on the way it's going to be presented on that. So exacerbations, if it's something that, again, if that's a working under duress exacerbation, it's just daily living exacerbations. Not everyone can just crawl in bed. They're going to have to do some type of activity. Now, if they're doing a restriction that they strictly prohibited from, you've got a fracture in your arm. I told you not to lift more than 15 pounds, and now you've re-broke your arm. I mean, that's just, it doesn't matter what you call it at that point right there. They're clearly not, they're not being compliant with the treatment plan at that point there. Hopefully it's not that. Hopefully it's something of just daily activities and that sort of thing, and we all have to do something. Then it gets to the lawyer at standpoint to advise the client, like, try to be compliant with your treatment as much as possible. Stick to the treatment plan, stick to your visits, stick to your restrictions on that as much as possible. If you can't, then we have to explain that away the best we can. So it's always good if they can follow it. Now, is it good to tell a patient that they should be off work 6 months for, a mild strand sprain? No, it's not going to fly. So it doesn't matter at that point. We have to be reasonable and realistic about the restrictions that were in place on that stuff. Can it last 6 months? Yeah, it can. When you get up to the surgical levels and you get up to, failed surgical attempts, it's going to require a second round of that sort of thing. You can get all kinds of stuff that can be explained away. So it really depends on the nature, extent of the injury, I guess, as well, and the circumstances. If you got a lawyer out there and he's making a recommendation to do something like that, work with him at that point. He's going to be the one that can use that to get it. I can't talk for somebody else's style.
Yeah, but to you, those two words are interchangeable.
For me, depending on the nature, extent of the injury, I would say. Okay.
The social media is I tell all our patients, we had one denied because she posted her running a marathon like 2 months after the accident. And the attorney called me and he said, hey, they checked it. We're going to court. You better pull back.
Yep, and in ways that they don't even know that was when social media became popular and people start privatizing their social medias, and even if they might have a friend of a friend. You'd be surprised how many people actually, have you ever looked up and absolutely know people and these suggested friends, and they know 3 of your friends, and they might be able to see that stuff. I tell I've got so many clients, I warn them right up front, even my new case video for clients, I warn them right up front. Stay off of social media. Talk about Happy Mother's Day. Talk about that stuff there. Do not show you lifting your child up. Do not show you, going on vacation at Silver Dollar City and jumping up in the air and having fun. You may have hurt like hell, but you know what? The insurance companies use that against you, and they can during discovery in a lawsuit, they're like, I need your username and password to your social media. All your pictures, they're going to print them all off. They can get that stuff. And there's no way we can keep it out. So, and YouTube, it might be YouTube, you might have an MMA boxer. Yeah, I do MMA on the side, dude, you had a car wreck 2 weeks ago and here you're in the ring 2 weeks later. You're doomed. Was the pre-existing condition, pre-existing injuries, were they asymptomatic? Like I mentioned before, if they had a condition and they were released to full duty, why does it really matter? That's really not a pre-existing condition. If they get hurt again, well, it's been re-injured to a spot that's been injured before. Maybe they were predisposed to the injury, maybe not. But I wouldn't call that a pre-existing condition. Pre-existing condition was I was symptomatic before this crash. If you know the patient's history, if they're a previous patient, you're going to have a better advantage to be able to do that because you got the records. At some point, you may be held accountable to making a comparison to, well, where they were before. You had a previous MRI before, and you got this MRI now. What's your understanding? They had a 2 millimeter C4 bulge 4 years ago, and you did an MRI and you got a 2 millimeter C4 bulge. So the insurance company's not going to be impressed with the distinction between that. You're going to have to come into some ADLs. Yes, they were, but this time around, they couldn't do this. 6 years ago, they didn't have a 2-year-old daughter. Now they do, and now it aggravates that condition. So be mindful that you may have the same type of situation, but the lifestyle has changed. The ADLs have changed.
If they've had multiple accidents, do you recommend, and you're aware of them, do you recommend us stating that they've been in 3 previous accidents?
I think it adds you credibility to do that. I think they're going to find out. I think it adds credibility, or be prepared to address that. I do full disclosure because to me it's like I can make that argument. Well, they were predisposed. If it was something that was truly a pre-existing condition, well, that's going to go towards a duration on the second accident. And now, well, you shouldn't have treated 40 visits. Well, you know what? They didn't have a perfect neck. They had these problems before, and I could work with that. So thank you for coming, folks.
Excellent.
Thank you.
See you next one.
All right. I'll try to speed through on here. Okay, so I think at this point right now, subsequent injury is something you need to know about also. What about a re-injury? They had the car wreck, and a month later, they have another car wreck, or they fell in the shower, or their dog yanked them off the sidewalk, or whatever the subsequent injury is. You need to be aware of that. There's nothing worse than having a car wreck, treating, and then a month later, 2 weeks later, whatever, they get into a second one. What happens then? Lloyd, do I have two charts? Do I have one? I said, well, we have to look at the facts. What's the property damage on the first one? What's the property damage on the second one? Let's play adjuster for a minute. How's the insurance company going to evaluate this? So let's take a look and make a comparison to see, do we even want to open a second one? I mean, it may just be for, car damage only and not any injuries, because it was only $200 on the second accident, but the total loss on the first one, well, tells me that if we try to open a second injury, then we're just going to complicate the first case. So are they really hurt? Is it something that maybe a little bit of pain, soreness, their pain level's really the same, range of motions are kind of the same, a little bit, but not bad? I think we can probably talk about that, but it's not really a subsequent injury. It's kind of just maybe a somewhat of an aggravation, a mild aggravation. Let's look at their activities. Well, they're still able to still work. They're still able to sit in front of that computer and whatever the case may be. We're going to have to distinguish it some way. Or sometimes it may be a better situation. What if the second accident is totaled and the first one was just a minor door ding? We might want to focus on the second one now. So there's no rules, no hard and fast rules how to handle that, but we do need to know how to address that situation. It's going to be different for everybody.
Close out the first one and then start billing for the second one?
Could be, if that's what the facts merit, or it may be both are open. What if it's a neck injury on the first one and specifically a back injury on the second one? Neck is not even affected by it. If we can demonstrate that, then we might have 2 independent charts right there, two different cases. So it really depends.
Put the blame game on the
Yeah.
other one.
I've got a knee in the first one, I got an elbow in the second one. It just really depends. We have to take a look at it, but it happens quite frequently. It puts some thought, and a strategy needs to be in play there, because you'll be ambushed if you don't. Because it's easy to defend those things. Insurance companies know how to tear those up really easy on that. But it can be navigated to get around that. Okay, I'm going to move on a little bit quicker on here. It's always good to note if your injuries are permanent. When you do a final prognosis, if a person ever anticipates this person is going to have problems in the future, guarded prognosis, or I need to come back every 6 months or 1 month, follow or come back as needed, put down what you think as far as some type of future prognosis. If a person here, generally if they're going to say, well, I anticipate they're going to need care for life, that's fine, but we're going to need probably backed up with a stronger measure in there somewhere, a second opinion on that. Orthopedic specialist is always good for a consult on that. I know that you guys would probably be glad to see those folks if they need some help like that. Or you guys only do straight from the ER?
We primarily do trauma from the ER,
Okay.
but we do have referrals like for second opinions occasionally.
You want to introduce yourself to everybody here so that everybody has an orthopedic connection?
Yeah, I'm LaDonna with Orthopedic Trauma Services of Oklahoma, and this is Melinda.
Who are your physicians?
Well, we have 7
Okay.
and 1 mid-level, Norris, Stafford, Dumay, who's over with us now.
61st and Hill, right?
51st, yeah.
51st.
Yeah.
And you see third party bodies.
Not as a new patient, but if they come through the ER as a trauma and it's due to third party, those are the ones that we see. But if you're trying to refer someone to us that is third party, we don't.
You won't see.
Because we're strictly trauma.
Okay.
Yeah. So it's a little bit different for us.
Well, Tricia, you're no help. Trying to open your network up. Okay. Yeah, I'm just kidding, right? All right. All right. So I think, okay, just everyone should know at least the record laws in Oklahoma. I think everyone will probably be familiar with that. If I ever get into a situation where the record is going to be huge, I'm going to always ask for digital records. If it's just, 10, 15, 20 pages, I'm going to be doing the old traditional one. But you can ask for 50 cents per page, plus the shipping and handling, plus the $10. You can ask, because a lawyer or an insurance company, you're allowed to add $10 onto that as well. So 50 cents per page, plus any postage. If you're going to fax it, then there's not going to be any postage to it.
Darn.
Let me say this, and she said that. We do exception on the case by case. If there's got a really serious injury, because our doctors are specialists, and it is just, third party, then we'll take a look at it and review it to see if there's something else.
Okay, perfect.
As long as we have all those key things in place
Right.
and so forth. yeah.
Enough money to
Yes,
give me a surgery, obviously. you wouldn't be able to
exactly,
pay for the
yeah.
surgery.
Yeah, so we will review those.
Okay. Any questions on this? Do you guys know how basically it works on that? Do you know what a digital record is? That could be email, that could be on a CD. There's a lot of things that fall into that category right there.
This is probably a dumb question. It says 30 cents per page. What if you do it as a PDF document? Is that considered one page, even though there's like,
I would say you can. I wouldn't say so much that's a digital with a PDF.
okay,
I would say that's just a.
okay.
Yeah, I think that's a paper document. Just happens to be an electronic format.
Okay, okay.
The digital is where we're requiring you to go out an extra step, and it's usually meaning like a flash drive or a CD or something like that. And it's usually for large documents.
And that goes with MedPay or liability?
Yeah, as long as you get a medical record request with the HIPAA request or the high-tech request and whatever.
So if we're just submitting to MedPay to get paid and we add that charge, they usually deny it.
I probably wouldn't charge them for those because you're wanting to get your bill paid, and so if they're requesting it from you, if you're making a claim, I would not charge them for it. You can try it if you get paid for it, great, but they normally don't. They usually don't pay for lien fees or copy fees if you just submitted that off to them. You're supposed to give them an itemized bill anyways with the lien, so they should never charge for that. Okay, so I've copied the statute for you for medical provider statute, Title 42, Section 46. And I'll let you guys read. I've written actually the parts here. I've him for your own historical reasons. I've got it for your own historical reasons, but I'm not going to let you read those now. But they're here, and I'm going to go ahead and summarize that in the interest of time, what our lien statute does. All right, so Section C is probably the most important part relevant to you on that, and I don't know what page that is. But, so we do have a law in Oklahoma that allows medical providers to file a lien for services rendered to patients that are going to be making a liability claim. There's somebody responsible for it, or an insurance company responsible. And the statute says you not only have the lien against the insurance company, but you also have the lien against your patients. And that's what A and B is. One's for the patient, one's for the patient's attorney, and the other one's for the insurance companies. So it's kind of a multifaceted, they call it assertion. When you assert a lien, you're putting a lien against their proceeds or their settlement. We've got liens against the patient's attorney, and against the insurance companies. And basically what it does is just get your lien, get your name put on the insurance checks. So that's how the insurance companies protect your liens. But you have to have a good lien. If you don't have a good lien, then the insurance companies don't have a duty. The attorneys don't have a duty. And the patient ultimately doesn't have a duty. So if you're going to do it, you got to do it right on this. So Section C explains that the lien's going to have the amount of the lien. It's going to need to have the name and addresses of the plaintiff, the patient, or excuse me, the physician, the clinic treating, the patient, the defendants, and you don't have to really put the addresses down of the defendants, just their names on that. You're not required to hire a private investigator to figure out where these people live. And their insurance companies. The most important ones, I would say, is the insurance companies. You're also supposed to identify their policies or claim number on that. So these are things that you have to do. Do not take shortcuts on these things. You have to have, if you know that there's an attorney on the case, you have to have their name and address, required. It has to be attached at the courthouse, an itemized bill. So, or it says actually a statement. It doesn't say a bill. So it doesn't have to have your bill. It doesn't have to have, protected health information on those bills. It could just be a statement. 25 visits, and the total is, $6,000, whatever the case may be. The more details you have, the better it is to give to the insurance company, because they'll be able to make a MedPay claim right off of that. So that's a kind of an added thing. Just don't put their Social Security number, date of birth on there, that sort of thing. You can redact that stuff out. But it has to be attached at the courthouse when you file your lien. So you have your lien document. Attached with that lien document is going to be your itemized statement. If you've got 20 pages of itemized statement, shrink them down. St. Francis will have a 15-page itemized bill, shrink it down to the size of a postage stamp, and call it the attached statement. And you've got to have a magnifying glass, but by you can see it. So save yourself some money, because it's $20 for the lien, $2 for every page attached to it. So you want to have that second page just one page. Shrink it down. Now, if it's something that's important, you want to get out to a MedPay, make sure it's legible. Make it a little bit bigger. It might be worth the extra $2 to give them 2 pages on that.
Double-sided, yes or no?
No, not double-sided.
So I called the courthouse to get clarification on that, and they.
Tulsa County?
Yeah, of course. Yeah, I mean, yeah. So they said that itemized bills do not need to be attached any longer.
Yeah.
So I've been sending just the lien and not the attached itemized bills. They said as long as you can just prove those charges are there, you'll be fine. So
I won't dispute that, and if you guys want to do that, but that's not what the statute says. All right. It says clearly, it doesn't say when to have that itemized bill attached to that.
the statute is, if we back up a page, is probably the one that's on here, so I can.
Title 42, Section 46, and it's, so if you want to call it a preference, it's a preference. But if you don't want to do, the second page on that, yeah, I would just
trust them that they know what they're doing.
yeah, yeah, because technically it's a notice of a lien, but it does clearly show in Section C, it says itemized C. It doesn't, not when it says sent by certified mail. This is all before. If you read, the way you read a statute, Law School 101, the way you read a statute is you have to do this, and this. When it gets to that and, that's everything after everything before. That attaching the certified itemized bill is before the part about sending by certified mail. So, and there's a case out there. So I don't trust a clerk to dictate what the state Supreme Court would say on that case. I'm just saying, that's just me, but if they don't want to do it, that's fine. There's some people I know that don't do it and they don't have problems with it. But honestly, it makes for a stronger case if your bill's attached to it.
On the initial lien, how much do you, if you're gonna do it the very first day they come in, and you've only incurred the exam and the x-rays, then you go ahead and file a lien for whatever, $400?
It's a preference. I tell everyone, get it to your preference point. Somebody $1,000 worth of treatment, then do your first lien. After that, they'll do an amending after that. So it's just whatever your preference is. Just so you know, whatever the insurance company gets, if they get a lien for $400 and they go to the patient and say, yeah, we're going to go ahead and, you want to settle for, here's $10. You want to settle your case? Oh, sure, I'll take it. They're only obligated to cover your lien up to that point.
So how often do you recommend doing amended to update the additional cost of treatment, and then do you always recommend a final lien?
Again, that's going to be a personal preference, but I do recommend at least the initial and a final, at least 2. to protect yourself for maybe halfway through or initially up there, but it's a preference. And you know, if you got a patient that walks into your clinic and they say, "Can I get a copy of my itemized bill?" Guess what they're about to do? You better get a lien filed and say, "You know, I will. I'll get your bills and records to you, but you know what? You're on lien-based care. I've got to get this filed first." Yeah. So if they come in and if they got a flyer in the back to, you know, some kind of cruise out in Bahamas, you might want to get your lien filed. They're anticipating money. If they got a Best Buy, I had a client, so typical. I had a client, and I was about to settle a case and got an offer, and they didn't like the offer. "I don't want to take this offer. It's not going to take it. You know, it's worth twice that much, whatever." It just happened to be at Best Buy that evening, and there they were shopping for TVs. I go, "So you do want the settlement, right?" To have all the, okay, then you've got to, the statute actually says, you know, registered mail. You can do registered mail, certified mail, return receipt. I think you could probably get by with a waiver too, and we'll talk about that. And if you're an e-lien user, look at our forms, there's waivers there. Waivers basically say you can do it, you know, I, the patient, understand I'm supposed to get it by certified mail by statute. However, I'm waiving that, and I'm going to take it by hand, or I'm going to take it by email, or I'm going to take it by texting a photo of that to me, whatever. I'm going to waive the service by certified mail. So it's a little way to save some money on that, because the certified mail costs what? $860. So it's a way to save a little bit of, you know, overhead cost by just getting a waiver for the patients. Do I say it's ultimately no problems? I don't see a problem with it, but it's not what the law says. So, but you know, we waive, as lawyers, we waive stuff all the time. I even waive service to receive my clients being sued. Yeah, I'll accept service. You know, they don't have to send it to my, don't need a process server, don't need it by certified mail, just fax it to me. I'll waive service. Okay, so these are the people, of course, you've got to get it to. The most important people are the patient and the insurance companies, because if you don't get it to your patient, then you're not following the law. If you don't get to the insurance companies, well, who are you leaning that? You're leaning nobody with any money.
I had a patient that refused to sign for their certified mail.
They're served. They're still served.
Okay.
They're still served. The law on that is you refuse service, you're served.
Scan that in, like
Yeah,
okay.
they're served.
Okay, making sure.
Yeah. The defendants, of course, you don't need their address. You don't need to serve the defendants. People know that. The insurance company is what's important on that. And their patient's attorney, if no.
I have a question on that. Is that statute, or is that your recommendation to mail it to, certified to the patient?
That's statute. But I'll promote waiver on that, because waiver is an acceptable practice within the legal business. Is everybody here an e-lien user? There's a new feature on that. I don't know if you know this. The new application of e-lien now, the old application was just antiquated. It had been around since 2007. The new one is more modern, but it's got some other features in there. It's got the forms, and the forms got a waiver in there. It also has the easy steps for filing liens that we're going over right now. It's on there. And then Titus, in the corner there, is filming this, is probably going to upload this whole video for us on there. So we'll be able to have ways to go back and refresh yourself on this. But the waivers will be on there, and you'll find those waivers very helpful on that. All right, don't need to go over this, but this is the statute of limitations. You need to understand that how long is your lien good for? Well, ultimately, your lien is only good for really the underlying debt is the patient owes that bill. That's a contract. So if you've got a written agreement with the client, that's 5 years that you can sue a patient for debt. If you don't have a written agreement with the patient, it's only 3 years, verbal contract. So you can never, your lien will never survive the original statute of limitation of the debt. When does that start? That's from the last date of your patient's treatment. That's 5 years. It can be extended. 4 years, 364 days, the patient comes in and gives you $10 to pay for their bill. You get another 5 years on top of it. That's a trick. Anyone doesn't know that on collection agencies? Can I get you to pay just $10? They're about to lose their statute of limitation. If you didn't pay it, by law, they couldn't collect that debt against you. They've only got 5 years to collect a debt in the state of Oklahoma. But if you make that payment, you've just extended it another 5 years.
Is that even if like they have an attorney? We had one, she had an attorney, she wasn't liking what they could get for her, so now she's moved to another one. It's been, I don't know, so even if they have an attorney, it's just 5 years?
Even if you have an attorney, yeah.
Okay.
Having an attorney doesn't get you any special privileges. It makes you smarter, but it doesn't get you any special privileges.
Would you just refile it if it's after, if you still haven't been paid?
You cannot collect on a debt that's older than 5 years in the state of Oklahoma. So your lien ultimately is tagged to that. The second statute of limitation that's in Section D that we're talking about is that to enforce the lien, you have 1 year to enforce it. You can sue your patient or the insurance company or the patient's attorney or all of them. You have up to 1 year after learning of a settlement or court award. So it may have been,
So if you file a lien and.
but it's got to be within 5 years.
And the patient has a lawyer in the beginning when you file your lien, but then they go in and say, I'm not satisfied, and they, do you have to file a new lien without the lawyer's name on there?
Are they getting a new lawyer or not? If they're getting a new lawyer, you'd amend
If
it.
they choose not to.
If they're not, then, you know,
It doesn't matter.
I mean, it's an extra party, so what? It's not relevant really, so don't waste the money on that. It will, the unfortunate part is the insurance company will add a lawyer's name to it, like what's on your lien?
Right.
And then you got to compete with some idiot who may not cooperate with you. So it's always good to have a clean lien coming out of the case, all the updated information on that. So I'd recommend. Yes.
It doesn't matter how many times you amend it, after 5 years, it's over, right?
Correct.
Okay. So if you go in after a certain amount of time, amend it, then that doesn't, it's from the last day.
From the, well, the 5 years is concerning the debt. So you got to take that lien out of this conversation for just a minute. We're only talking about what legally can you do to collect money from a patient. You have 5 years to collect money from the patient for the services they owed you, or 3 if you don't have a written contract. I mean, what's a written contract? Basically someone agreeing for services, agreeing for treatment. That's a terms of service. So that's, and I think everybody in here at least has something consent from the patient to treat, right? So that's a written contract. So there are some who don't, and you don't have 3. Yes?
If a patient is not available to agree to a settlement, and you're getting close to, you know, your time's running out or whatever, is there a way for us to collect without the, I mean, there's obvious fault, there's obvious liability on the third party, but the patient is supposed to agree and sign off for you to get paid. Is there a way the doctor can bypass that?
Yeah, absolutely. You can enforce your debt against the patient. Enforce you. You can sue them anytime. You got, aside from the lien.
From the third party.
Yeah. Yeah, you can go after, you can be because there is or no insurance or where the problems are, or there's a delay or not a delay, whatever. You can go after the patient anytime. Of course, you got to make a demand. Patient, it's time to pay. I'll give you 30 days to pay. They don't respond, or they, you know, you take out payments, whatever you work with them. If they don't respond, you can always bring a small claims court action up to $7,500 against the patient.
From the insurance company.
You can't collect it from if a liability, they're not going to piecemeal it out. They do one settlement all at once. That's all damages.
So you're saying you've talked to the insurance and they're saying we can't get hold of the
Yeah, we
patient
can't.
until
Oh, you can't.
we're not going to cut you a check.
Right.
And your patient refuses to call them back and settle.
And there's
because
nothing,
it's been 2 years.
there's no recourse
Say
we
they've been
have.
called.
Not against the insurance company, because you're not a real party in interest against them. But you can sue the patient. Go after the patient, garnish your paycheck, whatever. If they got nothing, then unfortunately that's the business sometimes. You know, if they call a lawyer might get them motivated, let them know that, hey, you know, you might have actually some money coming to you. I can't get a hold of my clients sometimes. I've called their relatives who I know they probably owe money to. You know, I got this settlement offer. Man, I can't find them. 5 minutes later, I heard I got an offer. Mom will find them. They owe Mama. So, okay. All right, so other things you should be aware of, some cases out there. This one here, which time we have right here? We got a little bit of time here. You should be aware of Liberty Mutual on the Broadway case. Liens are valid against UN MedPay. At one time, it used to be a question like, well, you can't lien UN or MedPay. Well, that case said, yeah, you can. That case also said that here's what I keep telling you, it's got to be done by the statute, because this case, Supreme Court case, even says it's got to be strictly construed by the statute. Strictly construed because it's a lien, that's a statutory lien, which means it's only enforced if you follow the law. The law says step 1 through 10, you got to do it. If you don't do it, your lien is invalid and you can lose, and that may be an issue of you getting never paid on it. Now, if it's within 5 years, you can still go after the patient. You can still sue the patient. Just because your lien wasn't good doesn't mean the patient still doesn't owe the money. But after 5 years, you can't. So that's an independent case. The lien has its own powers, and you have the right to collect from your patient, and if so, sue them. That's its own powers too. That's why I've got the 5-year statute and then the 1 year after learning of settlement record award to enforce the lien. Why would you enforce your lien? Because the attorney stole your money, or the patient never paid you your money. The insurance company forgot to put your name on the check, or they didn't issue you a separate check. Those you have to do within a year of settlement record award. Now you can, there's a little trick on that brings you beyond that 5 years on that, but you guys would have to talk. It's way too long to go into that discussion. There may be a way to extend that. And sometimes I've had an insurance company still honor liens older than 5-year debts on that. I've had a court honor it. So there is some latitude here. One thing you need to know, recent change here, this is last 2 years ago, your liens are only good for reasonable and necessary and usual and customary charges. So your lien dollar amount on there can be challenged by the insurance company. That's CSAA is also AAA, if anyone knows that. This clinic here, they lately filed a lien. The amount was already settled, but the check hadn't been issued yet. They finally got their lien to them, and the insurance company says, well, it's too late. But the court says, no, it's not too late. And then the other side said, well, if I have to pay them, but I'm only going to pay them for reasonable and necessary. We think their bills are too high. The court says, okay, well, bring your arguments. They brought an expert in, and that expert was saying, no, treatment was exorbitant. They could have been done within half the bills, half the treatment time, whatever. And they allowed it. And since that case, everyone needs to be aware. Now, that's an Oklahoma civil appellate case. If everyone knows the law, it's not a Supreme Court case. It may go to the Supreme Court, and the Supreme Court may say something different. But for right now, this is the law of the land. So your liens can be challenged for the dollar amounts. And what would happen is you would get a notice that some attorney wants you to, they want you to take a reduction. And you say, no, I'm not going to do it. So the attorney files a DEC action, a declaratory judgment action, not an interpleader. Interpleader is where there's not enough money to pay everybody, and here's the money's court, and please disperse this on a pro rata basis to everybody but me. As a lawyer, I get paid first. Who knows? The attorney has made that law, right? So on the DEC action, you actually are being brought in as a party, and the attorney is going to be bringing in evidence to show that your bill's too high and that you should only get awarded for what's reasonable and necessary, usual, and customary. That's the difference. That's what an interpleader is and a DEC action is. Interpleader, you can't challenge the reasonable and necessary of the treatment. It's like, we have no arguments, we just don't have enough money. There's $100,000 of medical bills, but it's only $25,000 worth of coverage. DEC action is, it's whatever the issue is that the plaintiff patient wants to bring by and through their attorney to challenge the lien holders on that. And this is the case would be, so be prepared to have your chart notes backed up.
Yes. We just had an attorney file an interpleader on us when there is plenty of money.
Yeah.
The patient's getting $16,000, and he's asking us for a 50% reduction.
I would say that that would be all the attorneys that are defending that will challenge that, because that's not the way it's supposed to be. The interpleader is the patient doesn't, it should have been a DEC action. So in a DEC action, you can make those arguments. Well, they're not getting compensated, they're not being made whole, they're treated was too much and whatever. An interpleader is because there's just not enough money. Not because the patient's greedy, because they're crying in their soup right there, they didn't get enough money. It's that's a DEC action if they want to make an argument. So that may get dismissed by and through your attorney or one of the other attorneys involved there. That's not the forum for this. That's not subject matter for the case.
So I have another question. What if the patient takes out a loan, and then the loan company files a lien also, right?
Yeah.
And if there's not enough money, do the providers get paid before the loan gets paid?
The loan is derivative by and through the patient. There's not a lien for loans in the state of Oklahoma that gives them any kind of there's a name for it, priority of liens, that sort of thing. That doesn't give any placement in the liens. It's really that's a debt with the patient.
So if the attorney is listing that on the breakdown, then we can mark that out and say this doesn't apply,
that's really net for the patient. That's patient's net. They were advanced the net, but now they got rules and penalties. So an argument for the defense to make on that is like, this is ridiculous. This lien holder finance company cannot compete with medical liens. So that's just ridiculous. I won't even ask who the lawyer is. That's just ridiculous. So we've gone for this. We talked about that. We talked about the 1 year after one. Okay, section D. Oh, I'm going the wrong way. Okay, that's why we talked about it. Talked about that. Okay, amending your lien. We talked about amending your lien. What are the reasons why? The most reason why there are is because there's obviously more treatment. The bill is up. There's another insurance company party to name in there. You want to name all insurance companies you can. If you learn one later on, like, oh, you find out later on there's MedPay, well, get it amended because you want that money liened on that. There's an attorney. You learn of an attorney. You definitely want to get the attorney involved on the case. So those are the common reasons. E-lien has the drop downs where it's got the most common reasons on there. If you're amending it, you click amend, and then you hit reason for amending, and it's one of these 3 reasons right there. Everyone knows we talked about after the first visit, that's preference. If you want to do that, you can always amend it, later on at the last visit. We've talked about amending strategies. Managing your liens, don't file and forget. File it and follow up with the patient, insurance company, and the attorney and all parties. E-lien has a place to keep notes, or you can keep track of your notes on that, but if not, just keep notes in your chart to find out what's going on. Oh, I talked to Lloyd on May 10th, and he says the check's in the mail. Well, it's now June, and I don't have a check, Lloyd, and I'm being held accountable right here. Date and time and who I talked to. So that, thank you. And, okay.
All right, so steps to.
Can you go back to where it said don't, accept the word pending? I would like to go over that.
Okay, so if you call it attorney's office. Right. If they use the word pending,
yes.
To me,
litigation.
There's a cloud of secrecy that know. All right, well, what happens if the attorney calls you? So what's going on? Oh, it's just pending. The treatment's pending. How would you like that?
So we could say that to them?
Sure. I mean, if that's their rules.
I would love to say that.
But I mean, your ass kicking. That's pending right now. So yeah, just you want to get enough information. Like Lloyd, it's in demand, or Lloyd, it's in demand. It's going to take usually 4 to 6 weeks to get it settled here. We've got some stuff. We can't predict how it's going to turn out, but we can kind of give a timeline where it is in the process on that. People that want to keep it a cloud from you, be leery of. Attorneys want to keep it. It's a mystery there. That's an issue. You are the expert witnesses in their case. Is that how they treat expert witnesses? To give you no information whatsoever? Well, am I going to go to trial? Am I going to get deposed? No, if so, that's going to be a $4,000 deposition. I just want to let you know up front. Or you can cooperate. We can probably work with you on that price. I mean, I would be pissed if somebody just wouldn't tell me anything. And it's been like 2 years later, and you can go into OSCN and look at the docket. So if you understand that, you can OSCN, it's a free website, first name, last name of the patient. Hopefully it's on a common name. It's not John Doe. And you can, or if you get the case number, you can put it in case number and find it, and you can.
Their attorney, we have a patient whose attorney's out of Houston, and the attorney will not communicate with our office. They say they will communicate to our patient, and then that patient will communicate to us.
So how's that going to work when you're an expert witness?
I know. They will not. So what do you do in that case?
All right.
Respect your rules. At the deposition, when I'm deposed, you can't ask me the question. Under your rules, you'll have to ask the question to the patient. Only the patient can ask me that. Thank you. I'd have my lien in place on that one very carefully. Is this the McCormick Law Firm?
Oh, we've dealt with
Is that really a law firm?
Always,
Is that really a law firm?
yes, and they're always the one that uses pending.
I don't even, how do they get business? I don't even understand that. How does it even, like.
You are not nice. How do people like that?
Recommend E-lien on that. Again, you guys are the expert witnesses. There's going to be a level of cooperation on this stuff. They've got to be able to work with you on this stuff. Do they realize that you may have to testify? if they can't get it settled, and just by knowing the way they handle business, it sounds to me like a good chance they may not get it settled. Okay, so these are the steps again, and these are, I can just briefly, really the title says it all. I recommend your patients always consult with a lawyer up front. If they don't want to hire one, they should at least get free advice from the lawyer. I'm always glad to talk to your patients if they have any questions. That's where that's a lot of times I tell them what not to do. Do not give them a recorded statement. Do not let your evidence deteriorate. Videos, photographs, you've got bruising, physical abrasions. Take pictures of that stuff, it disappears. Witnesses move on. Defendants change stories. They need to be aware that the insurance company is not going to, they're not waiting for you to, okay, oh, John finally called, I can't wait to make an offer on this. That's not how it works, folks. It's not, you didn't win the lottery by getting into an accident. You do have a right for damages, but it depends on the strength of your case. Building that vase, shaping that vase is all it's about. And they at least need to know that there's an alternative of just, well, I could save myself some money if I don't get a lawyer. Well, that's true, you probably can, but what you're saving from reality is I get attorneys, experience get, I don't know, exorbitantly so much more than what they realize that they get. They're getting the tip of the iceberg as far as value of the case. Gather insurance information. You need the insurance information for all the liens. There's different ways. Get it from the patient, police report, a cooperating lawyer who doesn't tell you it's just pending. You want to draft your lien. Of course, to draft your lien, you're going to have to do it by statute. Make sure you get policy numbers or claim numbers, all the information you need, the insurance companies involved, all the insurance companies, UMs, MedPays, all the defendants. There might be more than one at fault. And that's something you can be told by the lawyer, or you look at a police report, and you can see sometimes there's 2 at-fault parties on these things. File your lien. Again, I recommend with a copy of the bill attached to it. The courthouse says it's not necessary. Well, I disagree. I respectfully disagree. I think it should be there. St. Francis disagreed. They file bills all the time with theirs, and they have an army of lawyers over there. If they can save that, I can bet you they'd probably save that money too. Serve your lien. So as I talked about, certified mail, if it's refused, it's still accepted, it's still served. Waivers, try waivers if you feel comfortable with it. You look on the e-lien website and it's under forms, it'll say service waiver. I've seen some people use, because of U.S. mail is not reliable, I've seen people use UPS or Federal Express on their liens and not heard any problems with it. I think they just basically mean traceable. You can be able to trace if they received it and prove that they received it. Amend the lien as needed. Manage your liens. We talked about don't file and forget, get information. Don't just get pending. If you get pending from them, see if the insurance company will share information with you. See if the patient will share information with you. If the patient doesn't want to share information with you, says, well, it's lien based. It was out of our generosity, we charge you a lien. It's not by necessity. I can collect this from you now. You have 30 days. If you don't want to give me information, then you need to make payment arrangements now, please. If not, I may bring an action against you to collect this. And your lawyer, who's supposed to help you on this, is hanging out to dry on this. So, take it up with them because it was their problem. I would be a little bit more assertive, and I know that these are nice people, but if they're playing that game with you and they're not going to give you information, well, how are you supposed to get information to get paid? How do you know it even settled? It may have settled 2 weeks ago, and the attorney's sitting on the check. Maybe it settled 6 months ago, and there's a big coup over your head, and you don't know that you're never going to get paid because they stole money from you.
They'll say that it was a minor and it had to go to different attorneys. I've been waiting on a check. They paid for everybody else but the minor.
Well, it could be, I'd call the adjuster, and minors, if it's going to be held through the courts, now they've changed the rules out there, so there's going to be a lot less court action with the new rule, but it's done by affidavit.
We had a patient that it was years, probably 3 or 4 years since her initial injury, and she'd come and then she'd have to come back, and finally the last time that she wanted to come back, we told him us that balance was paid, we couldn't see her. And she did pay it, but then I got a nasty letter from the attorney saying that we had a right to collect from her. And so forth. Yeah, and I see now for certain, we didn't do anything different. I was like, she owed the balance, it was her.
A lien is not a waiver of your ability to collect from the patient. It's just a guaranteed way to get paid when there's a settlement. It's not, it's a separate cause of action. What an idiot. A lien protection, basically, obviously, knows you get a perfected lien, a properly filed lien, they've got to honor it. And it gives you some rights to collect it, enforce it, if the attorney doesn't pay you, or if the patient doesn't pay you, or if the insurance company doesn't pay you, or all three. You can go after them. And there's parties in this room that I've actually represented and sued the insurance company because they didn't honor the lien. And every time, it's like a 100% success ratio. I've never lost a case where any of those parties have failed to pay a lien. There's a caveat. The lien has to be perfected. If you miss any of those, well, we didn't give the patient certified mail. Well, you don't have a valid lien. Unless you got a waiver, you don't have a valid lien. Well, you know, I faxed it to the insurance company. You didn't do it by certified mail? No, I faxed it to them, but they knew they got it. That doesn't matter. Strict construction, like that Broadway case said. The statute is strictly construed, and if you don't follow it, the court cannot award you that. So that's why I say, everyone, it's got to be done the way the statute says. Don't forget to release your lien after getting the money. If you don't release your lien, you can be exposed for damages, and that can be triple damages. So if you've got a $10,000 lien, they can come back and hit you for $30,000. They go out, apply for a mortgage, and mortgage company runs a background credit check and says, you got a lien against you from XYZ Clinic. Oh crap, I forgot to release that 2 years ago. If they can get approved for that mortgage, and then by the time they get approved, the interest rate's gone up another 5%. Wow, you know, watch out for that. Release your liens within 30 days of receiving your money, as a rule for that. I don't even know if there's not an exception for that. It's like a car. You go out and buy a car, you pay the loan off, and they never give you a lien release, and that's an issue right there. 10, that's my plug. Always call me if you have any questions. Step 10 is if there's any issues on step 1 through 9. Call me. Let me know. I'll be glad to. A lot of calls I get from people just like you say, hey, Lloyd, can I do this, this, and this? The same questions we have here are the most common questions I get on a daily basis on that. Dealing with difficult lawyers, you should know this, and I'll probably wrap it up almost real quick. A lawyer can't hold your check. The law says for ethical responsibility for attorneys is that they've got to promptly pay you your check, your money. If they've got a check for your name and there's no dispute, if there's no dispute, they have a duty to promptly pay you on that. Rule 1.5, they can get trouble with the Bar Association if they're sitting on your check. Now, if they do have a dispute, they'll get back and say, you know what, the reason why I didn't, because there's 5 other lien holders against it. I got to figure out something. If whatever the problem they say it is, or they may say, you know what, you charged for days, the patient wasn't even in town. If there's some legitimate dispute, the duty is, okay, well, they got to pay you the undisputed amount, and they got to pay that promptly, and then work out the details to figure out the dispute on that. So you have power over them as so long as you have a good lien. If your lien's not good, that won't work.
Is it normal for lawyers to hold checks for 10 days when they get them, for them to clear?
Yes, yeah. I mean, Bank of Oklahoma will release the funds a lot of times. If I have funds in the account, they'll release the funds. But if I was a smaller firm, I may not have the funds in the account, and it may take 10 days to go through the clearinghouse. So that's not uncommon. We always tell our clients it's 3 to 10 days, just in case. Because sometimes I'll see that it didn't clear, and it could be because the insurance company, there was a missed endorsement, and the bank caught it and kicked it back and whatever. And I can't give somebody else's money. I can only give the funds that are available, that are in the trust account on that. So basically, this is a continuation of Rule 1.15. They've got to dispute the undisputed portion of the funds promptly. Again, that's like there's something comes up like, hey, it's you charge too much or whatever they want to say. There could be some type of dispute, but it's got to be a legitimate dispute. They just can't make it up. Well, we think you charge too much. Well, your opinion has nothing to do, no bearing on my lien. Did you tell the insurance company when you settled the case that you thought we charged too much? Yeah, Mr. Adjuster, here's this bill from XYZ Clinic for $10,000, but I think it's really $5,000 is only reasonable and necessary. Can you just base your evaluation on that? No, they didn't say that. Wouldn't that any kind of a cheap shot to come to you guys and say that after the settlement, I think you charged too much?
But would that be the same for disputed dates?
Unless it's legitimate. Unless they catch it after the fact. Like, on hindsight now, we're looking at this bill, I think there's an error there. I'm not gonna call the insurance company up and tell the insurance company, hey, I owe you $50 for, one visit that you shouldn't have paid. And again, these are all the things that we've kind of talked about right here. This all applies, those duties apply to the med pay as well, to uninsured motorists, to the liability. Interpleaders, my best advice if you're ever hit with an interpleader is you're gonna have to have a lawyer. You can't represent yourself if you're an LLC. If you're a corporation or LLC, you have to have a lawyer. If you represent yourself as a sole proprietor, you can show up at the hearing. You don't have to have a lawyer. Represent yourself as afforded by the U.S. Constitution, but not with a corporation or LLC or some other type of entity, partnership or whatever. All right, that's it. There's all of y'all, we get a certificate of completion. Sure.
Let's say there's an interpleader, it says you can collect from the patient any undue, unpaid monies. Can you bill an insurance company for that, a health insurance, Medicare?
I've never seen that before. I've never seen that in an interpleader before. Would that be in the order? That's the order, or is that just the initial?
No, I'm saying after the interpleader is done and your fee is reduced, can you come back and bill an insurance company? It said that you can bill the patient for, can you come back and bill Medicare, health insurance?
Probably for the dates that are not paid.
There's some possibilities there, but obviously there's going to be subrogation issues, but time and filing issues is, I think you got to.
True, timely filing, true.
So that's, but yeah, you can collect it from the patient.
Medicare, you got a year.
I don't think Medicare wants to pay anything that was accident related.
They can, they might. I know even Medicaid, I know Medicaid doesn't cover chiropractic, but you have a 1 year.
We do now that you have to do that.
Well, I just learned something.
And it's not easy to.
Okay.
You fill it out overnight.
But I know they got a 1 year relate back. You can go 1 year back and get it. But so I would say yes. Depending on the circumstances. This is if you guys get time, I'd appreciate you. Just brings you to my Google rating. If you want to hit 5 stars because you think I'm wonderful, I appreciate that. You guys are always appreciated, and I appreciate your attending this and your good questions. I really appreciate that. Thank you.